remembering sections much, so when the procedural laws and IPC have been amended, I do not know where these sections have gone now. We do not have the new beer records, I guess, but with that as the three new officers will here today will be telling me which section is talking about what. Okay. You all will lead us to these sections. Now I think three are also now pretty seniors. So we leave sections now, We ask someone to tell what is the section, then we read it. So Naritya has joined the court, right? Now how you are doing? You can sit down. And at Rampur, yes. What type of cases are coming?
GR cases there are more.
SADA remands?
SADA.
Okay, must be quite busy court, no? And Rohini, after coming to Gangtok, how is it different? Little bit only. Ask Bevika. Zambia to some extent, he has also sat with Chuntan cases. So, it's Gangtok will be having the most, probably Rampur also, I don't know. We have a variety of cases, if you at 4:30, if you just try to get up from your seat, there will be many people waiting for you outside. But here, we complete the day giving priority to evidences, right? And then, but there are many other miscellaneous cases also at Gangtok. Remand will be lot 164, TIP. Okay, every day you will be having 61, 64 at Gangtok. So all these things, actually it's a boon. I would say that one must get posted at Gangtok district. I do not know about Namchi. They say Namchi also has quite a lot of cases, but I think variety is at Gangtok. So if you are not ever posted at Gangtok, then you might lose something in our state of the process of learning. So in this, even me, as an in charge, I was CJ in Gangtok from 2000. In fact, when Mr. Surat Shetty promoted, I was given the charge in the year 2016 itself. So from 16 to 2019 December, I was at Gangtok. Still, I tried only one case, of trial of warrant cases by magistrate. Otherwise, then on police report. Only one. That's the scarcity of this type of trials. But if you go to other courts, I think Jabian knows it. In Bengal, there are a lot of complaint cases, 200 CR. Especially, I think they deal with this 125, right? It's complaint or it's what do you do to 125? Rohini is also there.
125 they have miscellaneous.
How you start the procedure? It must be either warrant case, someone's case, on complaint.
Not on complaint, actually an application is filed, and then we take it as a miscellaneous case.
I think that's not working. If you could see, Mr. Manoranjan. So let's talk. All of us know law, including the two new.
We register it as miscellaneous cases.
I can still hear you. By the time they make it, I can hear you. You can still hear you. Yeah.
We register the cases as miscellaneous cases, but then we proceed with the DDR cases here.
No. Bengal.
Bengal, exactly. We register it as miscellaneous cases. No? Application is filed, then the other party is summoned.
Okay, procedure followed is a DV case.
Yes.
Is that correct, Mr. Zadhan?
So I only had civil court.
No, in any case, from your viewpoint.
You have not done any 125.
Here though we don't do it goes to family court. So I do not know, what was the going, if you could explain me the process. What sections of CrPC is in one?
125.
No, that is
just because it is considered as a quasi-civil and criminal, so we proceed it as a miscellaneous case.
Okay, any West Bengal rules on that?
No, not exactly. We just do it like that as a practice.
Okay, we will not stick to topic too much. Whatever I know, I will tell. Of course, we'll cover the topic. But how do you deal with this 169 police act cases that come to you?
No, we don't have 169.
No, here.
Yeah, I've never actually encountered.
You come through that.
Not yet.
Maybe can.
So mostly they take it to look at that, and that's where they settle it 169 mostly.
Yeah, there's a high court notification, I think. But if it does not get settled, how do you proceed? Let's ask new ones. Naritya, let's begin. 169 Police Act cases, have you got?
What?
Then there is one useless,
One cases,
I would call it a useless section. You know.
one case was there.
Now what you did, tell us.
It came to Lok Adalat and then I settled it. So I don't know what to do if it is not.
It came directly to Lok Adalat.
Yeah.
But is that correct?
We referred it to once it was.
That's what, no, you referred it, you, as a magistrate.
No, the police says police will file under 169 and yes, we put it in Lok Adalat.
How do you put it, tell me?
Okay.
No, there's a process, no? 1, 2, 3, 4 step.
No, we registered it as a Lok Adalat case.
How can that be? Any difference of opinion? Say, a criminal case has come to her. It's a criminal case. She sent it directed to Lok Adalat. What process is flawed out here?
So I came to know from Peskar Namchi, what he said is that 116 cases comes, then they transfer to Lok Adalat.
Where it comes?
It comes first to the court.
Yes,
Then
yes.
it will be transferred to Lok Adalat, but the case number remains the same.
No, let's forget about case number. So, Nairitya, why did you do that?
Because that was being
Let's be frank,
followed.
there's no one is going to tell you, and I've been here for the past 13 years, these discussions, no one will do anything. Okay, be frank.
So, because that was what I was said, it is being followed. So,
That's what, no. You know, Honorable Chief Justice would hate if you use this word, follow. Every time we get bashed up for, following past practice. In the administrative side also at High Court, many times I have been on the very receiving end. At least twice I remember, Okay, what is the most important aspect of, criminal trial? When it first comes to you, what do you do when it first comes?
We issue processes.
No.
Cognizance.
No, yeah, cognizance. So how did you send a case which even you don't know whether it is an offence or not? Should I in the Lok Adalat settle a case where there is no offence at all? If you read the 169 police, I won't call it a charge sheet, I have a reason for saying that so far, okay? If you read it, sometimes there is nothing there. You can refuse cognizance. Why you are burdened? There is one concept of, at one point of time, everyone looked upon you as a very good judge if you were disposing lots of Lok Adalat cases. Right? So maybe that got stuck, I don't know. I never believed in that. If you have 5 cases, 5 cases. Okay, if you in Mangan, I think she was there in Mangan. Initially in Mangan, there were no cases on 5, 6 on the board. Right, so one could send it to Lok Adalat and show some work also, but I think that's a different thing. Of course, still in our system, quantity is very much measured than quality. I'm talking about the entire judicial system in the entire country, okay, not specific to our state. So, you didn't take cognizance only. You send it directly to Lok Adalat. There may not have been any offence. If there is no any offence, why should the 2% be put to the process of law? Right? So no, that's wrong procedure. You first see it. If you take cognizance and if there is material under 169, usually there are no material under 169. Police thinks whatever comes under 116, but 169 you see is exhaustive. There are clauses A to something. Okay, like someone parking a vehicle, more than that is required. Some people, some cows or whatever it is crossing the road, whatever to whoever it belongs. These sections are there in that one. And there's one a very broad section, I think it's clause 169A1 or something, which is quite broad. Police try to cover it. And how I realized this was once in Gangtok, one case came, okay. And then I read it, it was saying that, initially even I was doing what he was doing, send it. But it takes time to settle in the court, right? Even if you get to transfer to East especially. Your predecessor will be having one practice. Your office will come to you and say, this is it. Initially you won't be able to know it, but you will know it later on. Husband and wife were fighting inside their homes. What offense is this? Someone said they got disturbed. Get disturbed, there's no problem. What offense is this? I can shout at the top of my voice inside the house. You get disturbed at your side, I think you have to come for what? In torts you have to come. Torts nuisance. And show me a word in 169 Sikkim Police Act where there is a word nuisance. Which, means every kind of thing. So be careful on these things, okay? You send to Lok Adalat. If I was the party, somehow we can be parties, right? It's not that judgment. I would have directly come to you and said, madam, what you have done, I will not contest, there is no offense. Right? So people don't know, okay? People are not aware of. You sent it, and how did you settle? If you remember that case.
Sir, with the fine.
That's what. What fine? How much? But why are you saying fine? Is it a fine in Lok Adalat? Okay, you try to see if you go back, if you ever get time, see you drew the award? Read your award once. What is it? Okay, award is of settlement of dispute, not a fine. So you are not sure also that whether there is an offense or not. Okay, in that way.
Actually, there was an offense that was.
What was the offense?
The person, it wasn't of course it wasn't a.
Yeah, it's always a
Yeah,
nuisance.
there was a fight between the neighbors that was due to the water. It was a nuisance kind of the water from one person.
Now, how is it a nuisance?
No. Okay.
If two people fight at a public place, it's an affray. That's the offense.
No, so it wasn't. They fought because of the fact that one person's water from the tank, basically of one person, was coming into the premises of another person's, and it was continuous. It was continuous for 6-7 months, and they fought quite a few times, and
They boxed each other.
yeah, there was the man actually hit a lady, the neighbor's wife.
Okay, what offense is that? If it's an affray, I think affray is non-cognizable, right? So they could not have. Now one more thing in 169. Now we are all over. We are citizens. We will hardly be dealing with. Now I'm just the two of them are citizens. Maybe Rohini will deal it. Okay, 169. Is it a cognizable or non-cognizable offense? Offense under 169. See,
I think it's cognizable.
yes, it's cognizable. Now, can you have a context of saying this? Okay, how can you say it's non-FIR case? Tell me. If any one of you can, satisfy me with this, this would have gone with FIR if it's 169. This one, non-prosecution, NPR, non-prosecution, they come under this. So the actual procedure, if they are coming under this, is under 200. I have done it under 200, 169, few of the times. Okay, but it took time. Later on, once you are strict with these procedures, 169 will not come to you. We can't be post office or police. Two people, either it was a civil problem, or even if it was one. Now there are two aspects of, some people will say that, our society, let's settle it, whether it comes under 169, let's, put the fellow to the process of court, police, so that they won't do it again. That's one. If you are onto that, that's none of my saying. But if you go by legal process, right, 169 is a cognizable offense. Of course, a cognizable offense can be complained to the magistrate, but not under that NPR. Non-FIR, something they say. I don't know what is that non-FIR report cases. Can there be a non-FIR report cases? It's either complaint case or FIR. There's no way out. So it's up to you. Now you three are there, right? We tried our bit on our part when we were in the court. So it's either a wastage of time, and you not dealing. Because see, there is one case which was, I think they went for, I do not know whether it was revision or appeal. 169 case, long time back, reached High Court. And High Court has made a very difficult remark against the whole process that was going on. Okay, so you have to be one fine day, someone might go. So stick to the process. What's there? Our job is to stick to the process, so that Otherwise, if we go by the practices, some of the practices were really a different kind, not according to the prescription of law. So in that context, and you will think over it, right? Whether 169, a cognizable offense, can come as a non-FIR report cases, and you can issue summons without examining the complainant. Okay, you see to that. Because that report does not come under 173 also. It's not a charge sheet. So there's no question of taking cognizance also, thinking that it is a FIR case which begins with 154 and ends with 173. So this is a thinking process. It takes time to change this thing, but be careful on this. Okay, any one of you have done this trial of warrant cases otherwise than on police report? Yeah? Or Bengal? Okay, tell us something. Let's hear from you. Tell us the procedure. Tell us the procedure.
It's basically a complaint case.
Under which act? Under which law?
CrPC, sir.
No. The substantive offence was under which?
The substantive offences here is under section 498A.
Okay.
498A.
It's punishable up to 7 years. Huh?
Up to 7 years, so it's a warrant case.
Yeah.
So what happened is, they will file the complaint. Thereafter, the complainants and witnesses, if any, are examined, and if there are sufficient prima facie materials.
Witnesses, if any.
If any.
Let's read once again. You give 244, no? 243.
244 is the examination of the complainant. After that, issuance of process.
After?
Issuance of process.
Okay. Okay, yeah, 200. Begins with 200. Yeah.
After that, once all these persons are summoned or warrant is issued, after the process is served, thereafter,
For the process, what did you say?
first
200.
200.
After that, there is this issuance of summons.
Yes,
I'm
sir.
sure.
Yes, sir. Issuance of
No,
summons.
let's read. Okay, she has different views.
200.
Let's give the leader.
204.
No.
After
No.
204,
No. Okay, let's pass over.
I think the complainant has to be examined, sir.
No, I think she examined complainant.
complaint has been examined. Thereafter, if there are materials, we'll take cognizance. Then, thereafter, we will issue the process. Thereafter, when they appear, the prosecution, the complainant will examine the witnesses before charge. After that, if there are materials, then charge is framed. If not, the accused persons are discharged, acquitted, discharged. But then, if there are materials, then there will be evidence after the charge. That is what we do.
204.
204, thereafter 244.
Okay, are you guys getting it? There is a difference between the summons procedure and summons trial and warrant trial when instituted on a complaint. Okay. So ordinarily under 200, if it's summons case, we examine the complainant. Now witnesses, if any, are we compelled to examine their witness? What does this if any mean? Anyone? Suppose usually complainant only comes that day. So what do we do?
It would depend upon the facts of the case. I guess.
Yeah.
If there are any witnesses, then they are bound to produce it. But then if there are no witnesses, then they are.
Yeah, absolutely. So this, see, under 200, a magistrate taking cognizance of an offence on complaint shall examine upon oath the complainant. This is mandatory. You have to examine the complainant on oath. And the witnesses present. It says and the witnesses present. Does not say who is not there, if any. As she said, you cannot be very technical also with this. If the witnesses are not present, but you are finding, because the complainant gives a complaint, it's in writing. And you will find, such particular witness will depose this. If you find that you need to examine more witnesses, though not present that day, you can defer it to another date after examining complainant and ask him to bring those material witnesses which you think are material for you to take cognizance, issuance of process. Right, so it need not be, now one might read it as witnesses if present. Now no one is present, there are 3 material witnesses listed in the complaint and you are of the view that I need to examine them, you are not satisfied with it. Because why this examination procedure is there? If someone is coming to court, see, one could, even in cognizable offence, people can come under 200. There's no problem. But cognizable usually they go to police with an FIR, cognizable offence. But once someone is coming to court, it means they have come directly to the court. It's not as easy as filing a FIR. Police are very less powers. If cognizable information is given, they are bound to register a FIR. But you as a magistrate, police will not apply their mind. The only thing they will see is whether it makes out cognizable offence or not. But 200's, prominent thing is that if someone has come before a magistrate, would you act? oh, complaint came, Cognizance taken, issue something. No, you have to apply your mind. More than what is done under 154 CrPC while registering FIR. So that is the reason 200 is saying you examine the complaint on oath. It could be a cognizable offence also. Sometimes if the offence is of heinous, so if someone comes with 302, you would obviously guide that person to police station because that requires investigation. Usually people come under 420 also. Usually for this complaint case comes under 420. God knows why they don't go to police station. Maybe they have something to hide. Right? Or another thing is they don't want all these investigations. They want to send directly summons from the court. They will be bringing materials before you. Okay? So that they can bring the fellow to court. These people are more into settlement nature. Let him come to the court, we will settle it. Okay, of course some offences like 498A has to be complained. Either by the aggrieved or someone, what is that? Or someone who, relative or something it says, of the aggrieved. So, I think bigamy also, no? All those offences related to marriage, Cognizance is barred under CrPC, under some section. Okay, except on the complaint made before the magistrate. Now, this complaint word is sometimes used interchangeably. While recording evidence, someone was complained to the police. Don't write complainant in your evidence. Write the first informant. The fellow is not complainant because CrPC has specific definition of complainant. So you say first informant. Okay, usually judges write complainant in evidence. Or while discussing in judgment also, we tend to write judgment of become evidence of complainant, which is not correct. The evidence of first informant or leave that also evidence of PW1 or PW2, whatever it is. Okay. So don't interchange this word complainant and first informant without applying your mind. There is no complainant on the first in the case which begins with a charge sheet. Why? Because CrPC has specific definition of a complainant. And we are writing judgment in law, right? You can't be liberal with English also. If there is some definition and we are writing that, we have to be sure that this is the word that will fit in. So yes, and another procedure in trial of warrant cases, otherwise than a police report, is that even before framing charge, you can record evidence, right? Can the person be cross-examined?
If the other party, if the defense wishes, then he is
That's right. Whom shall I ask? Let's ask, she knows much more. Okay, read, Mr. Sessan, you read this one. Section 244, right? Read 244 and say whether at that stage complainant's witness can be cross-examined or even complainant can be cross-examined. 244. Evidence for prosecution. That's where from it actually begins. With the trial. Not even the trial, charges still not different. When in any warrant case instituted otherwise than a police report, the accused appears or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. The magistrate may, on the application of the prosecution, issue a summons to any of his witnesses directing them to attend or to produce any document or other thing. And if you see again the immediately subsequent section 246, if when such evidence has been taken, yes, you can cross-examine. Okay, when you rightly pointed out, you can cross-examine even before framing the charge. And under 200, as we said, we will be examining the complaint first once. Second, under 244 also, shall proceed to hear the prosecution and take such evidence. We can again examine the complainant. Okay, but by this time lawyer will be there. In 200 CrPC there will no be lawyer. Even if the lawyer comes, lawyer can come. Will you allow him to examine under 200? Negative. Why?
So that is because examination of complainant under 200 is between the complainant and the judges. That is to know whether to take.
But usually lawyers, suppose a senior lawyer comes with loud voice, okay? I'll examine.
No, but
What will you say?
Actually, that is the prerogative of a court because that is to take the cognizance, and I don't think so. There should be a
Yeah,
lawyer.
because examination is not formality. Okay, if you give to lawyer, it's just a formality. They'll read what is there in that complaint. Okay, examination means something is given to you. Mostly these complaints, or even if you see in civil case, claims are not very clear. Even plaint has a similar procedure. What is that? Why do you examine? Under order 10, right?
So yes, to see whether there is.
Do you allow lawyer to do this?
No.
You're still in wrong, no? Gangtok, we have allowed lawyer. Yeah. Me sometimes. But
That's a wrong decision.
yeah, they can do it, but don't let them just read it. Sometimes a seasoned lawyer comes and you with all belief, think that will do the job properly for you because you are already tired and there are some other things running on your mind also. Tomorrow there is 2 judgments to be pronounced. One you have not started also. All these things will run in the mind in the court, which it ordinarily shouldn't, okay? But yes, you can allow a lawyer. These are all the internal things of the court. Forget about procedure. Internal things of the court. Someone might comment you did wrong. Okay, someone might take it to another level also and say, oh, this was happening in this court. Just for one instance you did, right? But yes, that court is yours and sometimes you need to handle it outside the procedure. So lawyers can do it.
Sometimes lawyers they themselves prepare and bring it in a pen drive. This is the exam.
Yeah, that pen drive system had started when we were in Gangtok also. That was more easy, actually.
But I didn't allow. Because I had
No.
time also.
Okay, yeah, very good. But if there is something fruitful in the pen drive, you are saving your time, no? Okay, give it, put it inside, see, you can make any change. Some are really formal only. You make certain changes and that's it. After all, it went through you, you did not allow them to paste it on your record. If you examine, that can be done, there is no problem. You can cut whatever is not required. That will save your time of typing or whatever it is. You can read it. Some lawyers bring good one, okay? They bring a good order 10. But usually their order 10 is of that one. See, facts you did not use. Certain facts you will have to state while examining also, while recording yourself. So you can, they will obviously return the facts. That will give, you can copy it and put it in there. That's your version, not his. Right, you can do that, there's no problem. That's an internal thing, very internal thing. But don't be like, oh lawyer, I want, come on, you give it, and then copy paste it and sign it. If you do that, then that's something wrong. So sometimes you don't have time to do all those things. So order 10 on the CPC is an equivalent provision, which is examination, which we routinely do it. And on the complaint case also, the complaint comes and repeats what is written there in his complaint. And that's really not a good thing. Because examination means you would put that complaint to test. You have doubts at certain things. And you may discharge also. There is a provision for discharge if there is no offence. And I think one of the case, it went from Benoy's court. Halim's, there was a complaint case on the 420. You had taken cognizance, or you had refused, I'm not sure. Something happened. There's a very good judgment. My laptop is not opening, I don't know why. There's a very good judgment of Honorable Justice Bhaskar Raj Pradhan on this taking of cognizance. It could be applicable to someone's case also, why not problem. The crux is, complainant had come with a very beautiful petition. Okay, saying so many things. Obviously they'll have to say. And in the end, the person was saying, I was cheated, there was a breach of trust, so many things. And in the end he said that, therefore the offence under section 420, 471, or of all those 467, etc. are made out. It was Halim's case, 2 parties fighting on the criminal side also. And then whether she had taken cognizance or not, I don't remember. Okay, I could say one thing. I could quash the proceedings, saying that in the complaint you just can't say, I have been cheated. What are the facts that leads to your cheating? That must be there. You just can't say breach of trust. Lawyers will come this. Therefore, breach of Mr. X committed breach of trust against me. Okay, look into this, but these are legal words. But what are the facts that are constituting breach of? This is the thing which you need to examine. The fellow is talking nothing about cheating, and he wants you to take cognizance under 420. You can give him scope, even though it's not written in the complaint. Okay, you can give him the scope to say further in your 200, not just to stick to that. Of course, what will be its outcome in the end when he has not said something in the complaint, but said to magistrate under 200, that can be adjudicated in the end. Okay, whether that would have any value or not. But not just, the complaint using all big words of law, using sections and saying that please take cognizance. That's place where your role comes up. How have you been cheated? What are the facts of you being cheated? What did you do? Cheating requires two very important ingredients. Deceivement and what's that? Deceivement and one more, what is that? Whoever deceives and that causing is there. Initially there is the deceivement and inducement. If these two things are not there, see, a person might say, he took my money from me, didn't return. Usually these 420 cases comes in money, didn't return me back. Therefore he cheated me. He gave his money voluntarily. Okay, did he take the money intending not to pay? These are very important ingredients that must find mention in the complaint. Can't wait for evidence to come, can you? But we have a tendency of, okay, that is there, let's go for it. Because we have very less cases. So, be careful of this thing. There is, I don't remember the judgment. I have said Halim is there, HALIM, one person who unfortunately passed away. And then that's his case. Justice Bhaskar Raspadan judgment is there. I think if you type Halim, okay, let's try it. In the Jamana of net. You didn't sleep, by the way? Yesterday.
I slept so.
Netflix? You may have slept, but at 2 o'clock somewhere or 2.
Yes.
I slept at 12. HCS.com. Because the search parameter now is. I think Geo works better than our Wi-Fi, right?
Yes, sir.
What's this? She said, what is it? I won't joke with it. What works in Benoy? Nothing. Okay, just search it. My net is not working at high note. If you press Halim, there is one criminal revision petition. You gap हो इसको क्या है इसको very important. You can always rely on that if someone is coming with evasive complaints, right? But don't be very deep also. Okay, I don't mean you have to be very deep at that stage. Now next we'll come to prima facie also. If you type Ruth, I think Ruth will be not Halim. RUTH, Ruth. CRP is there, civil criminal revision petition. No, not that. CREP. See that? Yes, of course. This as well. Can you say loudly? What's the name? Acha, Monroe, give her the mic. You read the almost last paragraph of Justice Pastor Rajpadan. It's just last or second last, wherever it is. So very well written.
Last paragraph.
You see where the crux is written, that just mentioning the section it would not suffice.
This court, having examined the complaint, the evidence and affidavit of the respondent number 1 and the exhibit documents from the respondent number 1, is of the firm view that there is no material before the court. Before this, I think.
Yeah, before that.
The respondent number 1 had arrayed the 4 petitioners as accused in the complaint. There is no allegation whatsoever that they have conspired with each other. And
They have conspired with each other, 120B, right?
Or caused to be done in illegal act or an act which is not illegal by illegal means. The essential ingredient of the offence of criminal conspiracy is the agreement to commit an offence, and the said ingredient is missing in the complaint.
See, well, once I had done one case where I had said its fortune became something else where I had said, and on the warrant trial, discharge the accused. I refused to take the cognizance itself. Forget about reaching 244. I said there's no material to take cognizance of the offence. Merely saying that I had been cheated would not suffice. And I said the ingredient of the offence which the complainant is alleging is missing in the complaint. I won't say what fortune that case landed on. Ultimately, it got the same fortune what it got at the stage of me not taking cognizance. But it went through whole process. Okay, that my order was set aside. But this judgment gave me the confidence. After that, I kept on thinking, how can we not deal with ingredient when someone is coming with complaint? Now read it again, please kindly, loudly, what the Honorable High Court has said.
Before this, I'd like
Okay, there you go.
what has happened is, in my court,
She knows the facts. It was.
I'm not talking about the fact.
Okay.
Now what has happened is, in private complaint only, before we take the charge of this court, what has happened is the cognizance had already taken.
Yeah.
Under what we okay. There was no what do you call that, pre-summoning of evidence, no examination.
On the warrant trial.
No, pre-summoning of evidence, no complaint was, complainant was not examined, nor their witnesses. Now the cognizance has been taken, the summons has been issued, the accused are here, and now they finally, the charge stage is also gone. Now what am I saying?
Tell them to go and get it quashed. That's the only way you have to
They
district
are not
judge.
just complaining, they want the accused people to stand in the dock and face the fact.
No, you need to say warrant trial procedure is not there.
Not there.
So only I think what you can do, you cannot say, because even if your predecessor has done it, I hope it's not me, isn't it?
No, very easy.
Okay, the culprit
Very
is there.
easy gazing
Why?
back,
What?
very
It could be.
What happens normally? So,
Yeah.
It is not from your part.
what happens normally is that we either frame substance of accusation or charge, but we follow the same procedure. Summons procedure in all the cases. So that is what has happened. I think.
No, that was a private complaint.
So you're only, no, it's a private complaint you're talking about. You are what you're talking
No,
about.
but it's really unfortunate because 420 the procedure, how will you do?
No, what's your stage? You better not go with the trial. See,
CC is already.
you can't say, my predecessor did something wrong. I want to change it. There's no process in criminal law of turning the clock back. Right?
So it's already done.
That's what, no, now, if any other course tell me, I am finding it, you tell the, whoever is complainant, the accused side, go and get it course, always another complaint can be put for it. Any other view on this? What's the way out for a magistrate? Already, some procedure has taken place. Accused has been summoned wrongly, without following the process.
Without following the procedure.
Now you know the process is absolutely wrong. Even if you write a judgment and the other person is clever enough, you get it.
And
What?
there was one similar.
And
We have a similar case, one more is there. But now there was, the only thing I could do was hear them on CC. Because accused are already there. Complainant has already filed.
revision can be preferred before the district judge also. District judge is well within the powers to say the process taken is wrong, to start the trial day over. That is one way out, or get it quashed from the
Or
high.
hearing on charge about what we came to hearing on charge.
No, I told the accused that something has occurred wrong out here.
No, I haven't.
Who is the lawyer? If you have the confidence with the lawyer, then you can tell the lawyer.
The complainant should go to the
No, why will he complain? He complained it. No? Okay, of course he is also at the risk. Yeah. Yeah. Complainant can, if he's accused, he will obviously go and get it quashed. It's complainant, tell the complainant lawyer to approach the district judge and get it revised order.
So what about hearing on CC and then passing an order that there stands no chance for the sections of law?
No. Okay, well you can do that and finish it off. But still, that discharging of yours also is not about the process. Because if you discharge, someone will definitely go and point out that not only you are discharging wrong, your whole process is wrong. Okay, if they don't go, you have no way out. If you are finding grounds of discharging, you can discharge, they will obviously go. And if they are clever enough, they will tell the district judge to do something. And once it comes back, even if there is no order that your discharge is wrong, I think you can, but still no, the district court must say that your process of initiation is itself wrong. That will give you a ground to start from beginning. But if I would have been a lawyer, I would have gone and revised it. No, why would I allow my party to suffer? Are you getting? Because now, see, we are talking a little bit above them. Okay, we are not talking about the ground processes. So you all might find it, God knows what they are talking about. So anyway, you can come in and tell them. No? There is a process, okay? In someone's trial, you do it with one process, section is there, warrant trial, some sections are there. In police report cases, the process is almost the same. Police report means the charge sheet. Right? But when someone complains you in warrant trial, complains you under 200, the process is different. Complaints in a sense come to the complaint before you under 200 CrPC. First you will examine under 200, that's known to you, okay, or witnesses. Then the accused is called. Then again you will have to examine the complaint and the witnesses. Cross-examination can take in place here before framing of charge. Sections say so. Okay, so there is a difference. What are the warrant trial cases? This you all must say. Anyone of you do. What are warrant trial cases?
2 years and more imprisonment
Yeah,
or death.
right? She's right? Okay. Any offense which is punishable by more than 2 years. But should be punishable by more than 2 years, right? Should be punishable. So these are all warrant trial cases. There's a different process of trying these cases when a complaint is made to you under 200. The other processes, when it's a charge sheet, it's the same. So, any other thing on this which you are going to tell? So, read that. I interrupted you there. I love that word, you know. That it gives us so much scope to magistrates. Ingredient. Try to read it loudly.
The respondent number 1 had arrayed the 4 petitioners as accused in the complaint. There is no allegation whatsoever that they have conspired with each other and agreed to do or caused to be done any illegal act or an act which is not illegal by illegal means. The essential ingredient of the offense of criminal conspiracy is the agreement to commit an offense, and the same ingredient is missing in the complaint.
See, the ingredient is missing in the complaint. There is no allegation of that sort which attracts 120. The paragraph previous that it may be something else.
Previous to that, definition has been cited. 128, definition of criminal
Okay.
conspiracy.
In any case, this judgment is very important for you all, okay? It talks about that, you know, the complaint, the allegations must make out the ingredients of the offense. If someone comes and says that I was hit with a rod, what comes? Judicial? What comes? If there is an allegation in the complaint, I was hit with a rod by Mr. SJA, I stopped there. What offense is committed? There is no medical injury report put back by him. Nothing is there. What offense is attracted?
No offense.
Oh, I hit you right now. You say that I come here, so committed no offense. That too with rod. Obviously, you won't keep quiet. I'm just giving my example. Someone hits you with rod. Wouldn't you feel that you have been offended? There isn't here. What? Tell me. Why are you?
Intimidation.
Oh, yeah.
Intimidation.
What is the offense when we usually deal in court? No, when they say hitting with rod, usually you get the rods. What?
Assault.
3 to 4. 3 to 4. But this fellow has not brought medical report also. At the max, it can attract 3 to 3. Is the complaint giving an ingredient of 3 to 4? Just because he was hit with rod. Hurt must have been caused. There is nothing regarding hurt also. At the most, assault may. Not assault, criminal force. And by word assault, I again remember one thing. We use this word assault very poorly. Okay, Narita said, explain now.
No.
We use this word assault very poorly while recording evidence also and in judgment also. Assault has a specific definition. What is assault? Do you have to hit someone?
So it's just
Yeah.
intention.
Yeah. I must apprehend that someone is now about to, that's
When
assault.
somebody is apprehended.
If it exceeds more, But less than causing hurt, it's criminal force. Right? So there's a fighting case, you keep on writing assault, the fellow assaulted. The legal definition is something else. There's a case of someone boxing. So don't write assault. He assaulted, so while recording evidence also. Assault is something else. You just raised your hand upon me is assault. Legally speaking. So we must be correcting this words. No? Whenever there is a definition, we must use it as per its definition. So that's what I'm trying to tell. There is a judgment of Honorable High Court which says that you can, while examining the accused, see or looking at the complaint also whether there is ingredient or not. Even if it's not there in the complaint, you can elucidate something from him. That's the point of examination. Not as what is there if you are just to read what he has written. But yes, do this only when if absolutely required. If you are feeling sometimes what happens, the fellow's petition is drafted very poorly by the law. Why should he suffer for that? But if it's deliberate, drafting, if he wants to tell that much only, you must be very, very, skilled in examining these people, even on the order time. It's not that, you can just examine. Don't think that it's a power given to me. I can examine. You must have the skill of examination. You will not want to take out what is not required to be. You have to be very careful. It's a case. Someone is telling you that this has happened to me, kindly do something on this, right? But a balancing act is required. The fellow might be you will know it as a judge. After a few years of experience, the person standing before you, what he wants, you will know it, everything. And that will influence your mind. Okay, that will influence. You will not be sitting like a blank sitter. I'm not talking about prejudice. But you will be influenced to a certain extent by just, how that person is giving evidence before you. Sometimes we might be absolutely wrong in judging them. We start judging, not only writing in judgment. We start judging the moment the person comes before us. And mind you, you will turn into all these things in your lives also. You will, in every other thing you will start judging unless you are very cool enough. But that coolness will go after 4 or 5 years. You can be cool for 4 or 5 years. That's the max, I would say. Then after all these things will, come on to you. Your personality, of course it will not change your core. But you will be looking things in the outside world also from the very point of what you are doing in your job. That will make you, that will cast you in that way. But be careful, this is also a negative thing. You try to be yourself. It hasn't been very much possible for me. I have fights at house. They say never bring a law in law. But I find it, you become logical in arguing at house. Obviously the people at house will give you, there's no reasons. This is it, right? You'll be trying to reason in it after having worked as a judge for so long. So we begin judging from the very beginning. From the moment the complainant, you look at him, his complainant, who is the lawyer also sometimes puts you, it gives you something. I'm not saying to change your mind. It gives you something that will, that will pave your way of thinking in that particular case. You will not think alike in all the cases. If you are very good. And then, now the fellow doesn't want to tell to you also. Why should I say it? Sometimes lawyers stand up and say, no. You will not say, I've given my complaint. There are lawyers, okay, like this. So you deal with them the way they are dealing with you. So no need to be, too much of a good judge and try to pull out everything which, changes the nature of the complaint itself. And your examination is a detailed complaint rather than what is this. It's useless, to be frank. What will it be? It's not there in that's his document. This is what he said in court. The another accused will definitely say he did not say these things in complaint. And you're bound to consider that. You cannot become his or her spokesperson. Do that much which requires for you to understand what the person is telling. And if you're understanding a bit and not more, leave it there. If it is making out the ingredients, leave it there, take cognizance, do the trial. In the end, what happens, that's none of our problem at that stage. Okay, so, but don't try to make out a case of him which he himself is not there. So we must be, so that's why the examination under 200 is an art. Don't leave it to lawyers. You have to read it before examining the person. Of course, sometimes we don't get time. It depends on the nature of case also. Sometimes in a very, a case which is seems to you very complicated also. We might not get time to read, but try to read it and come prepared before examining, so that you can ask questions, you can listen and think whether you should do something on that or not to do on that. So reading that complaint before examining is very, very important. Of course, we tend to do this very less. Everyone will say that. It's difficult to practice what you preach out here also, right? Because we all are human beings. Sometimes we don't get time. Sometimes even if we get time, we have some other engagements, which is more enjoyable than reading that. Of course, this happens. It happens to everyone. Ask any judge. Come on, I have not read it. And this one, let's deal it in the end in the judgment. It happens, okay, in busy courts like Gangtok. So after we examine now first we examine the complaint, witnesses if we wish to. Usually we call some of the material. There are material witnesses. In offences which are punishable up to 7 years, or more than 2 years, warrant trial, there will be material witnesses. Just complainant cannot prove anything. Be careful of this. These are the offences which is not heinous, but in between, okay, between the petty and heinous. So there's these offences there. So they will be having some kind of witnesses. So you will examine that issue process, accused comes. Again you will be examining the complainant. The thing is out there, the defense, so most of them don't know the lawyers. They can cross-examine. They don't know. Okay, but you can always tell them, you can cross-examine at this stage also. And after cross-examining, cross-examination, whatever comes, then only you decide to frame charge. In trial of warrant cases, otherwise there are police report. Okay, now one more question to you all. What is the standard of framing charge across all the whatever type of trial or offences, including sessions trial? What is the standard that we take? There is one word also. Yes, prima facie. Now what is prima facie? Whom should we ask?
On the face.
Yeah, on the face, literal meaning. Suppose there is a theft case, right? And then the evidence is CCTV footage. The accused is seen in the CCTV footage in a public way, which is right in front of the house where theft occurred. The accused is a habitual theft, alias to be not convicted yet. You will get all this thing. I am giving a practical example which happens. Is that sufficient to frame a charge? He is seen passing that house on the public way. Is that prima facie? Of 380. That's the only evidence police have. He was seen at that point of time. CCTV will show time. That's at 12 o'clock at night. Why would a person be there at 12 o'clock? A very big question. Habitual theft. He stood before you for 3 or 4 times. Then it is saying no. Right?
So even if we frame a charge on the basis of prima facie, it is prima facie, the ingredient of the offence must be seen, even if it's prima facie. So for theft, if the person is lurking around the house,
Not lurking, don't say lurking. Lurking means
if the person
at least trespass and doing that.
loitering around the house of
Not loitering, he was passing.
passing by the house.
Okay, loitering also will take it, he was loitering.
Or
Maybe he was planning
in
to
occurrence.
commit theft, which he never did.
So I don't think so. I take it as a prima
Yeah, I agree with that. Any other view on this?
So out here also I feel the same, because prima facie means that whatever is there, without testing it, you should feel like yes, it will result in an offence in conviction. You should feel like that.
Yeah, even but this is a very simple example, Ali. There will be some more. This one vigilance case, I don't remember the Honorable High Court had discharged the accused. That's a quite lengthy one. If you read that, then that judgment does tell what is actually a prima facie case. This is very little. Okay, even if we had found inside, if the CCTV would have caught him inside the house, then prima facie is there. Right or not? But what change did come for theft? He was outside the house, he is inside the house. Maybe trespass. But how we changed our mind? No, there is prima facie for theft.
Because there's more probability.
Yeah. He may have. So what does the section say? It does not talk about crime. It says that we must be able to presume that the accused has committed the offence. Isn't it a sufficient and reasonable presumption that you was inside the house, you are the thief, even though nothing was recovered from there, from him? I think to frame charge that is any other way. It can still be debated, you know.
Now it's becoming even more confusing.
You are seen inside there.
He was inside the house. And
Theft occurred, fact is there.
After a event, it's confusing.
But it's not seen committing theft, okay? I think to this extent we can frame charge, right? But still we know nothing is going to happen, but that's not the criteria so far what law says. It might change in future, right? But you know, just seeing him outside in that public way, passing through once, police are writing in the charge sheet, he is a habitual offender, obviously it is he. Nothing was recovered. Okay, in that case I discharged, but the very evening he was again brought in another case. So these cases, so prima facie, you know, so is there a different standard in warrant crime? Okay, there should be a prima facie. Where you have read this? You have read somewhere, no? Prima facie. Where you have read this? Which judgments tell us that, you know, we should look only prima facie? It's mostly in the sessions trial case, 299 no? And it's these judgments of prima facie, I'm just opening a mind, okay, I'm not saying it, that, you know, there should be prima facie material to frame charge. The landmark judgments are for the trial of cases instituted on police report. I did not find any such landmark judgments dealing with this section. So because why I am asking is the standard different? If you read, no? What are the other sections that tell? That you must have sufficient grounds to presume that the accused has committed offence for all other kinds of offences you are trying. But what does the section say regarding trial of warrant cases and complaint? You have recorded evidence also, you have allowed cross-examination also. So do you think the standard would still be the same for prima facie?
it's a bit higher in this case because
Okay, can you explain higher?
because the complainant has been given the opportunity to present all this evidence. So the standard is obviously higher compared to other cases where the prosecution has not been given the opportunity to produce evidence.
If upon
He
taking
is bringing it, I mean the complainant is bringing all his
but
evidence.
the materials and evidence has been tested to a certain extent, right? Even before framing charge. If upon taking all the evidence referred to in section 244, that is evidence before framing charge, the magistrate considers for reasons to be recorded that no case against the accused has been made out. Not only that, which, if unrebutted, I think Jabrang and myself had a long discussion, Urvashi also, they were still under induction. I had this case. If unrebutted, would warrant his conviction. And this is the only section where I find it talks about, you know, if that what has come to you is not rebutted, you will be convicted. Isn't that the standard required to frame a charge? If you are finding, even if with that evidence, the person is going to get acquitted, should be framed charge. I don't know that. We are telling a lot on this. If unrebutted, would warrant his. Now, what is warrant? Warrant is conviction means, in all probability, he is going to get convicted. If that evidence is taken, okay, without further rebuttal. Because there is one more process where the prosecution can still bring the other witnesses. And I think accused can further cross-examine after framing of charge also. In fact, you have to ask him whether you want to cross-examine any further witnesses, any further. I don't know what is the reason behind making this process so complicated, but it's there in the law. What's it required?
I think because there is an investigation of the police, so I think this is the way for the average.
But we cannot investigate. No? We will remain within our controls. Right? What can max we do? 311? What's there? 311, 165. Evidence Act. that really does not lead to any investigation. No, attend me. So what is the standard? Do you all agree that the standard is with others is same? The standard to be taken out is same as what we take for trial of warrant cases on police report at the stage of charge and discharge. Then how do you decide what is prima facie on this? All the precedents that you have is of the other ones. See, my laptop is not opening. I brought this laptop thinking that I will give you few judgments because I have dealt this case and it has gone up to High Court. Okay. And then, so there is a detailed discussion on my part as well as the judgment of Honorable High Court. Name of the case, I can give you the trial, my trial case name. I think you can find it High Court. It was a Customs Act case. Something Bhutia is there. I had discharged the accused after, recording this, saying that, evidence, even if unrebutted, would not warrant the conviction of the accused at two grounds because he was not searched in front of customs officer. This 102 in Customs Act, which there was one High Court judgment which said that it's equivalent to NDPS. If you have to be searched before the magistrate, you have to be searched before that. There they had not done that. And in NDPS cases, we have not followed this procedure, it's acquittal. Okay. I had used that and said, and some other thing, because there is one more judgment of Honorable Supreme Court which says that the evidence which you have taken before framing of charge can be considered to find out if there is no material at all to proceed further. So I had said that the standard is different. All those judgments which are there on prima facie of that. Now here it talks about not the presumption, but something if unrebutted should warrant a conviction. The lone section in the entire CrPC which says so. Still Honorable High Court now, which is the judgment for us, it says that the whatever it is, prima facie standard is the same. It was not the judgment doesn't mean that there is no difference. What the judgment is meaning is you cannot go away from prima facie. So the Honorable High Court reached a conclusion that there is prima facie materials on the face sufficient to frame charge. Okay. But this aspect of whether it would warrant a conviction or not, it was not dealt with. But still, that is the law on our part so far. You can still read on this. Whether the discharging or framing of charge is two different standards. I did a lot of research on this. I reached a conclusion. I didn't find any judgment on that. But some of the judgments cited at the Honorable High Court level were some of the judgments which talked about the standard is same. I mean, this is where researching, I think, would be used as research something.
Yes.
So, even we as a judge, we need to be very good researchers. I did not find these judgments. Why? Because the thought process is different at different level. Now, obviously, it was the researchers, at the High Court who found those judgments. What my thought meant was, there are no any such. I tried a bit, I didn't find anything, and I did not go deep into this section. I only, looked for whether the standard is different under the two provisions or not. So there are judgments which says standard is same. But what it is trying to tell is prima facie. Even in this it's prima facie, even in that it is prima. Now what things are to be considered, that could be different. Okay, but it does not change the standard of prima facie. So that was there. I couldn't, by the time I could conclude this case, I didn't conclude, I got transferred, okay.
So what was the case?
Dasang Bhutia. DASANG. Dasang Bhutia.
That gold bar case.
Yeah. With the strength of one of the Honorable Supreme Court judgment, I almost conducted a mini trial before framing of charge, which was wrong on my part. But I relied heavily on that judgment, saying because you can take all those things, okay, which are there. So I was only reaching one conclusion, this fellow cannot be convicted. I was looking for mouse out here. I said, you take out the judgment. This was reversed and sent back to the trial court for framing of charge. You need this. Judgment nikalo. Okay, prima facie खोज्यो। Standard what was it?
Rules of law laid down by the Honorable Supreme Court in the judgment referred to Supra. I am of the considered opinion that reiterated here that, in terms of section 245 of CrPC, the learned trial court is indeed required to examine whether any case against the accused has been made out, which, if unreported, would warrant his conviction. And in such a circumstance, the magistrate should discharge him. However, the learned trial court weighed the evidence furnished at this stage on golden scales. The evidence is to be examined for the purpose of a prima facie case. In the instant matter, it prima facie appears that gold had been smuggled into the country by the respondent from Ringchengang Tar, seizure of which was made by the SHO said in MPS in the presence of the witnesses, that in terms of notification so-and-so, dated so-and-so, as amended subsequently, gold is not permitted to be imported from China into India by individuals. In light of the evidence, a prima facie case has been made out by the petitioner against the respondent, and the order of discharge of the respondent is thus perverse and not sustainable. The imputed order is accordingly set.
No, find that standard. What standard?
Standard.
Just refer to my judgment. Okay. One of one. No, I can see that. No, whatever it is, what the Honorable High Court has said is that, even if at that stage there is evidence before you and can take into consideration whether the accused can be convicted or not, but you cannot do with so many golden scales. Right? That was the exact word used in the judgment. It's still a prima facie. So you have to be very careful because the prima facie of this under section 245 and 239, the scope is different. One says presumption, one says if unreported should warrant a conviction. So remember this judgment, when we are dealing with trial of warrant cases and you reach that stage, this judgment will come to be helpful to you. Because this is Union of India versus Dasan Bhutia. Okay. This is the only case I dealt on the warrant case at Gangtok. She has dealt on the 490. Other districts I don't think so. There ever exists also. And record also you will not find. So this may be the only one you will find in at the High Court level, this one and that one, that Ruth one. Ruth is at the stage of, taking cognizance. This is at the stage of spreading of charge. Okay, I think it's a long judgment. I had written about more than 50 pages. How many pages are there? 14 paragraphs, it's quite a long. 18 pages. Okay, so the judgment has dealt with the law on this aspect extensively and it will be helpful to you. Then next process it follows the same, right? Anything need not be discussed yet. Okay, we'll talk about one thing and we'll break, okay? Okay, what is number C? What is evidentiary value of the statement given by the complainant and his witnesses before pre-summoning stays in complaint cases? This is very simple. Anyone who would like to say on this? What is the evidentiary value? Just now we have spoken something on evidence also. I wish I could. If that case is referred, that case is not referred in. There is one Supreme Court judgment which talks about evidentiary value on warrant cases. There is no under 200, whatever has been recorded, does it have evidentiary value? No, it's not an evidence item. Right?
There's no, the accused did not
us to cross that. So
Yeah, yeah.
I think,
Yeah, exactly. But on the warrant cases, it does have some kind of. I wish I could. My laptop is not. There is one judgment of Supreme Court. You can consider it not as an evidence to do something, but if it is helping you to reach a conclusion, if the evidence is such that you cannot, ignore it. You have to consider it's a fact. That has been come with cross-examination, and someone is telling something which does not make out an offence or makes out an offence. So the purpose of framing of charge, it has an evidentiary value. Once you have framed the charge, even in warrant trial cases, that is gone. Whatever evidence comes now, next, is the one that you have to consider it as a true evidence. Okay, that's why usually in warrant trial cases, even after that second stage, the third stage will be a long one. Obviously now, if you are asking the complainant, you want to further examine, he will wish to examine, elaborate on what has happened in cross-examination, etc. It's a lengthy procedure actually. If someone wants to really contest on this, it's a lengthy procedure. Accused can further cross-examine also. Otherwise, see, my one view on this is, if you have framed a charge, well, what the law says, that if unrebutted, it would warrant a conviction. That means you have material for conviction, right? What remains unrebutted after you have framed the charge? He has examined all these witnesses. What I am trying to tell is, the section 245 says, if unrebutted, okay, it would warrant his conviction. Now, as a magistrate, before framing of charge, you are reaching a conclusion, this evidence is sufficient to convict him, right? Is there anything left after framing of charge? What is all evidence have come? What changes will come? So, most of the trial is actually over before framing of charge in this one, the majority part. How many more witnesses will the complainant bring? Obviously, at that stage, you will be examining material witnesses only before framing of charge. Accused will be, cross-examining the material witnesses to the hilt, as if it's a trial going on. It's a trial going on actually, right? So what would be left? Anything will be left after framing of charge. What is there to say now? From the viewpoint of complainant or even the accused, going trial. What is left? You have reached a conclusion that you can be convicted on that material.
That before the charge was framed, the complainant would only examine the witnesses. The defense, they used to decide the cross-examination before the charge. So after charge was framed, the witnesses would be cross-examined then.
Then you have a more ground of, I think they are doing that because you have more ground of discharging the accused if it's not cross-examined, right? Or more framing of charge. Because the complainant witnesses and himself will be giving incriminating statements. Right? The opportunity can be given, the fellow may not take. You can compare. So that has more chances of reaching a conclusion that if unrebutted would warrant that conviction. Okay, let's take an example. I think that's an incorrect process applied. It depends on case also. The lawyer might use his brain, whether to wait till that time or to. Because what will that happen is, he will obviously be cross-examining those witnesses only. And I think it can be done on the basis of what statement has been given previously. Do you need to record new one? I don't think so if this section. Of course it can be done new one also. But for the complainant also giving again new evidence will be a problematic because if there's a mismatch between what he has said before framing of charge and after, the defense will jump upon it. So I'm talking there is an opportunity cross-examination, done. You are reaching a conclusion, if unrebutted would warrant a conviction. What is left? No, see, if it's material, you'll have to examine. No, let's say in this Dasan case, one witness was, I do not know what they did later on. One witness was in ITDP, right? Pre-summoning, he was there, under 200. But later on, he couldn't be found. He got posted somewhere else. He couldn't be bought actually. And then, that witness can be bought? In my case, Of course, the complainant might say, this is very important. If they show to you the witness's material, you are bound to call out the 311. So they can, why not? Even if it's not very material, what bar would be if someone wants to say, I want to examine this witness, unless you find it's a waste of time. But it's just, so you'll allow. I think let's read this section. It says so. No? Why you cannot allow? Even I thought like the way you thought, but I thought new evidence can be brought. Because he still has the right to cross-examine. No? How much notice should a person should get that I will want to examine this? You can give 10 days time. Because I think, this you have seen in movies also. I think the way I've interacted with my other friends in Bengal also, they also say that, the other side says notice was not given. So what? No. How long a notice would you need to do the right thing? I'll give you notice. It's not that you cannot bring a new witness. Isn't there? 311 is there. That is the very purpose why 311 is there. In most of the other courts, the lawyers would fume if they would get it by a surprise that new witnesses come. Of course, you will not examine, but that movie shows no, that Jolly and the judge examines at 12. Can that be done? Tell me. Can that be done?
Oh, I don't know the facts of that movie.
No, that courtroom scene, where the complainant produces the witness and says, now if we leave this witness, he is gone. Okay, I want to examine that. Defense says, how can you do that? I do not know which witness what is going to say. Can we do that? The judge uses one word. Don't teach me what I can and what I cannot do. Though many parts of that movie, it takes the procedure somewhere. It's the PIL is running in the trial court. That's a different issue. But one thing he says, he thinks a lot, and the lawyer says, you can't do this. He says, don't teach me what I can do. It was 311 simply. Why I cannot do? If I have reasons to record that witness right there, I'll give you 10 days to cross-examine it. Coming by surprise, the defense can say, okay, I need some time. But why I should not record at least his statement in chief, evidence in chief, right? And if the judge thinks, if he has reasons to be recorded, you can ask the person to be cross-examined that day also. If you are getting a feeling, the moment you let this witness off, the accused people are so powerful, they have overdone it. Of course, this will be very hard to get sustained, if you allow this. But it might get sustained also, if you have a very good reason. The whole point in that case was, the complainant's lawyer's plea was, please examine this witness right now. And the judge examined it. That can be done under 311. So why I am telling this is what you are telling, why we can, how much long a notice should be given. So 246 says so. If the accused refuses to plead or does not plead or claims to be tried, or if the accused is not convicted under subsection 3, he shall be required to state at the commencement of the next hearing of the case, or if the magistrate for reasons to be recorded in writing so thinks fit. So here is a ground also, Mr. Rohini. If a magistrate so thinks fit for reasons to be recorded in writing forthwith, whether he wishes to cross-examine any, it says any, and if so, which of the witnesses for the prosecution whose evidence has been taken, already taken one. Okay. Now, prior to that also it is there. Where? 244. As may be produced, no? It does not exhaust. And one thing sure on this, procedural law will not exhaust anything.
246 6 says the evidence of any remaining witness for the prosecution shall next be taken.
So, see, in this context, what Rohini is and what he pointed out rightly is that remaining witnesses. So, does it mean that I need to list the witnesses at the initial state and this is my exhaustive? Cannot I bring new witnesses? It says remaining though. I considered this aspect also while writing that discharge order. I can bring, why I cannot bring if I have a material witness? For some reason I couldn't bring. Of course, it will not be, as a matter of right that he can bring anything. But obviously, we as court, if someone is saying, this is my witness, and even if he speaks 3 words, which may just support him, we will allow it. Because it's better to give. The fellow will rush to either district sessions court or high court, and at that level, high court will obviously think that, okay, let him say no what he wants. That's the whole point of trial. There's nothing legal about this at that stage. Give it. Why you are becoming so technical? Unless the fellow has nothing to say, okay, that is the different issue. But something to they'll say one day, saying I want to bring this. But you allow. Right, even if it's not 311. So, yes, they can do. But my question was, what is left? We have done it. Before failing of charge, the fellow is getting convicted in your mind. What is left to do now? Everything happened. He has been cross-examined. The evidence is there to convict him. So is it, what I meant to say is, see, that means once I frame the charge, the complainant is quite satisfied. Things are going on my side. What about the accused? What he can do? He can further cross-examine, okay, those witnesses. He cannot ask the complainant to bring a particular witness so that he can damage his case. Right, the case is almost, in this context, it's just a food for thought to you all. In this context, I am saying whether the standard is same. Okay, you all can think about it, because if the standard of prima facie is same, then we have finished the job at the stage of 245. You can well write a conviction judgment after that. Warrant a conviction. It's not, presume a conviction. Warrant is much more higher than presumption. Warrant is you are quite sure. This is the evidence on which I can convict the person. Right? So is anything left to do after 245? If not, then why would this process be there? So to my understanding, the standard may be a little bit of different. Usually people, once you have framed the charge under this, it's very less chance that the fellow will be acquitted. Otherwise you will discharge. Starting to say something?
So, in some cases, it says there is sufficient ground for proceeding. Then in charge on police report, it says there is ground for presuming that the accused has committed an offence.
So the standard has grown.
Clearly, the standard gets okay. It says that warrant is conducted.
Because all of the discharge judgments, these prima facie judgments, it uses one word definitely, that at this stage we are not to look into whether the accused will be convicted or not. So the whole thought process of those judgments are different than this. Here the word conviction is there. Right? So from that viewpoint, I did not find any judgment which deals entirely with it. I looked for a lot, but that was a very much loss for me, because I couldn't write it properly. I had to use my own, at that time you have to use your own brains. You are not getting any judgment to stand on. Okay? So from that viewpoint, that's why those judgments all use those words. I read all those judgments. That you do not look for conviction. It's prima facie. They are contrasting conviction and prima facie in those judgments. But in this one, how to contrast this prima facie and conviction? Because as I said, under 245 we are framing charge. We have solid evidence to convict the person. Right? What is it? Remaining witnesses one side that. Suppose if you go by that, witness the last one. Okay, those witnesses are there. Then accused cross-examine, what damage will cause to the case? Case is over, no? So, but I still have hope something is there out there. So, dealing with standard. I have not restrained them. Standard is something else. Either you usually don't frame charge, or once you frame it, the fellow is convicted. That's something which you can think of about this if you are dealing with this. We have 498, give a thought. Look for judgments, find out. We have vast size my literature. 494. Yeah, okay, leave it, because someone might be related or you get a call. So I get a lot of calls to tell someone the other. I said, I can't do that. Especially each case. You are in High Court, all those things. But one thing, I don't know whether it's, we are all following honest command. There is a notification from High Court there. Why that notification was issued for honest command? Tell me. Acha, no idea? Or say I or even what is Mahima? You know honest command judgment? Yeah? On top of that, there is a notification from High Court. Why was that notification? There is, of course, this is under direction of Supreme Court on judgment. But to strengthen the magistrates, if you don't get strengthened with High Court notification also, which I have not seen till date, people not, you will take the High Court notification to different level, not even to the extent what it was not meant at all. They are so religious with it. But this notification, the Supreme Court judgment, High Court notification, still magistrates fear not remanding the accused when there are no materials or when there is no checklist. I don't know, of the one of the case, I don't know. If I would have been there, I would have not granted remand. That too of 5 days. Then offense, when I read the things also, it was attracting none of it. And see, the police people are so clever. See, to be frank, they have misused the magistracy, okay? I'll tell you this. How did that person without bail reach another country? Listen, can it be? Once you have given remand, the only course left for the person is to apply for bail and go. I don't think the person went out on bail, or even he got as a bail. And the police gave a statement in media that on the judge's order we have deported the accused. Can you have a power to deport an accused at the stage of investigation? So I don't know, something wrong went there. So be very careful with this honest, not because one fine day someone might challenge and say, see, this is your notification to the High Court, right? I'm not saying you have to release the accused persons. But what process is there, follow it. It was not that sit with and mind, I'll release the accused honest command is there. But what it says, you do that. You can be strict and even if they have not brought the checklist, you can ask the police command. I really wanted to ask this question. That's why today, first I asked where is Lawrence Susan, because I wanted to ask this. I wanted to know what were the facts. I thought it's C and I called her up also.
She knew your process. What's up?
There must be some
She knew that you would hit her with that question.
some company. No, it's really the if that happened, what will it? I don't know. Because I'm going by what has been said. I cannot go and dig it. In India, it said the magistrate's order the accused has been deported. She vanished from police custody. Right? She vanished from police custody. The magistrate had given police custody. She was ultimately found in her own country. God knows how that person went. And police said that they released her. There's one section, which they released without telling us. What's that? One section is there. Somewhere around there. 169, right? Can they do that after 24 hours? Once you give remand, how can they release it? It's magistrate's order. Before 24 hours, do whatever you want to do. We are not bothered. But once you have taken my order of remand, then you cannot say that under 169 I release the accused. I am nothing. I was just used them. Don't you feel used? They use so cleverly. So magistracy is very important. The moment they know I can do this thing out there, that was quite funny to me. That's why I asked a few of them, what's happened, what happened. Because it's absolutely wrong. I must bring it to the notice of High Court. Don't you think so? It's absolutely wrong. Because it's not about a person, it's about an institution. Right? Just say, this has happened, what can it be? So, one thing also, police usually, they would say, they used to do when I was in the institute before that, released on the one side. What about my remand order then? The person is not brought on the third day. Then one small paper comes in CW, so and so. The accused has been released under 169. Of course, it gives power to SJA. If you read this section carefully, it does not talk about the stage. But I am of the view, once I give my remand, you cannot release him under 169. Because now you have given the custody of the person, arrested custody. I could have given JC also. Can the jailer release? Or can the SHO say, release him under 169? Because SHO has power. So what's the difference? It's the custody I have given. Now without my order or some order of the superior court, the fellow cannot go out. But the police said deported on the orders of magistrate. God knows what happened. In media they said. I do not know the facts, okay? Let's not be very prejudiced against something. This was what I heard and felt wrong. But still, it would be none of our business to dig into someone's false fact unless someone comes. But prima facie, we can always see it. So be careful of this also. So there is no evidentiary value of statement recorded under 200. In warrant of trial cases, it can be considered to fair charge. Right?
I wanted to ask your opinion.
Oh.
So there is an advocate at Namchi. So he has scribbles on his face, every month. And what has happened? In Jordan, there was some
Oh yeah, Jordan. No.
local awareness
also don't
going on.
We are looking at the Jordan also. No, right it is.
So what has happened, sir? So one of the speakers out there, some local person, he said that he was talking about SADA cases, how we should deal with
Legal
SADA
awareness.
not legal also, their own awareness.
Okay.
And what he said was that that advocate also, I have been telling him, Pak Laego, Besi, Sada ko, Wala, Chutara, this one actually. And now the advocate has actually filed a defamation case in my court.
Really?
And I'm like, of it.
No, Pak Laego, के भनेको?
Pak Laego चाहिँ थोका मुखमा खोका निस्केको भन्दैछ।
ए मान्छेले भनेछ
हजुर।
because he was defending those lawyers.
हजुर, सादा अक्युजहरू बेस डिफेन्ड गरेर सादा एनडिबिएस अवेरनेसमा चाहिँ त्यसरी भनेको थियो
But
मान्छे।
how would his reputation be affected? No? For me as a lawyer, if someone says, what is the crux of defamation? My
I
reputation.
got a little confused because for us, when we think about it, his reputation might not go down, but we have to think of the common people, like the villagers and all. They may actually think that, oh, it's bhako hala bhanda.
I know, defending a SADA lawyer is my duty, no? If someone
Yeah.
says,
So that is his duty. So the advocate has filed a complaint of defamation against the person who said all that.
but still his reputation as a lawyer, is it gone? I don't think so.
Not only as a lawyer, but moral reputation.
See, having pimples, even our friends, so many people would say that. No?
And some other person, in some awareness,
Yeah,
said
yeah.
that that lawyer, since he has acquitted so many SADA accused, paap lagera people are more. So that advocate has filed a defamation case in my court against that person.
It could be in common publicity, it's a matter that can be examined.
So I was like 2 months. Sometimes I feel like whether it will be defamation again. I feel like it may be also.
That's what his judgment is writing.
Because villagers and all might think like that also, no?
Yeah, but there must be evidence, no? Of those people who thought. You cannot assume it, even in defamation.
So even his cognizance have taken right now. So his family members or his other people might moral
Some people from
reputation also might also go down. Not only
the crux is that some people from the society must feel that, oh, suppose someone says me a thief, they should really have a belief, oh, this fellow is thief. That's the crux of reputation, even if it's not true. Okay, usually it's not true. And then, oh, this fellow, his pimples, the reason for his pimples should not be his acquittal. That's the thing, okay. But then in any case, that would not take his reputation as a lawyer. Who will the people take his reputation as a
but
lawyer?
not as a lawyer, but at least
Now, what would common people think?
common people will think you man, not a man is a criminal man. Get us drugs based man that's what the common people may think. So moral reputation
Could be.
that
Can be examined. But in this context, even if you have that some people from the society, not just today, you can pick up anyone and do. Some people who reputed people should come and and give an evidence. Others I can bring 5-10 people who will say that yes, I felt this fellow is bad. It must come from a person who really would be influential in the society. At least 1 or 2 witnesses. So there must be evidence that yes, we felt that he is a bad person. That's the crux. If that is there, of course, the defamation is there. But why? It's criminal or civil?
criminal.
Do what knows why they come in criminal? They should have asked for compensation, no? Okay, even if you have lost your reputation, sending someone to jail, what's the point? Ask something big enough. Right? So that after you win, at least your pocket are hot. And because in US we don't have the culture of torts and civil. No? Criminal. Torts, how many torts cases are there? None. So when damages, oh, give me damages. In the West it's more prevalent because that's how people suffer that pain. Even here people would suffer that pain, but we don't have that culture. So encourage torts if you want. So should we break for some time, right? And then we will go to another one. My director's questions only. The procedure for writing order of acquittal. Because I think he has quite a lot of argument on this, which we discussed over a long time back. It was Zabian's judgment. I think, I don't know, we'll ask him also what he says on this. 279 judgment, he forgot to write order of acquittal. And appeal was not entertained. It's your judgment at North. But I don't know if that would be correct.
Warrant was.
But that's order of acquittal.
In terms of the judgment, the summons was acquitted.
But that's order of acquittal. I do not know.
So after that, now what I started writing, it is hereby ordered also. I started writing
So even after, it was not in my mind also. What I did was I started writing order of acquittal in bold and then the remaining order. Could be what this time. It's not as examined this point exactly. But
this I've heard in Bengal also. There also, in judgment portion also they write it is hereby ordered. Even in the order also they write it is hereby ordered.
Yeah. Not only Bengal, all other states write this. I think we should write it to prevent any issues. You are writing, if you are acquitting an accused, no? You are a line from the king. Your judgment is there. What the next paragraph we write, prosecution has failed to prove the case beyond reason, thereby accused acquitted for offences. Right? So, no, I think that's why this question is there. What goes in writing order of acquittal in bold, and next paragraph you can write. That might save many. Because there is a provision in CrPC where appeal is restricted. Appeal is maintainable only against order of acquittal. So the Sessions Court would think you don't have order of acquittal, so the appeal is not maintainable. So where would the person go? The appellate court is saying, I won't take it as no order of acquittal. No post except going to High Court on the writ. So I do not know whether the director has more views on this. I have not found a single judgment which says how order of acquittal to be written. If there is there, I'll ask you. Can court dismiss a warrant trial case in the absence of complainant and witnesses without reasonable doubt? What would be the provision? 2? 42? 41? There's one more, no? In the absence of complainant and its witnesses, it says, the topic says that, I think under 249, the complainant is present, right? The complainant is absent, okay. And the offense may be lawfully come. So there are criteria, you just can't dismiss it if it is not an offense which cannot be compounded or is a cognizable one. What could be the course? When the proceedings have been instituted upon complaint and on any day fixed for hearing of the case, so the stage is the hearing of the case. The complainant is absent. What could be the hearing stage? Is it recording of evidence, under 200 or the evidence under 244? We can discuss on this. No, I think, let's say, conclusion of trial. If any case under this chapter, it's chapter, yes, chapter 19, trial of warrant cases by magistrate. It's under chapter, this one.
So it says before the charge has been framed.
Yeah.
So I think it is.
Yes. So it could be either the 200 stage also or 244.
200 or
44. Right? Because if those main persons are not there, but we should we go on directly, dismissing it, or should we give an opportunity? We can always give a notice. That, day was fixed for this, you are not there. Because if you at once, even under 204 or something, dismissal of complaint, even if you don't give opportunity, obviously it will be written by the appellate court saying that give an opportunity. So exhaust all the remedies out there. But see, 249 is very specific. The complaint is absent and the offence may be lawfully compounded or is not a cognizable offence. The magistrate may, in his discretion, notwithstanding anything herein before contained, at any time before the charge has been filed, it says discharge the accused. This one. Dismiss the complaint and discharging is quite different. No? Right. But this does not only relate to the question topic out here may not only relate to warrant trial of warrant cases, otherwise than on police report. It's also trying to cover than on police report also. So on police report you can't. Can you? You have to reach the conclusion in warrant trial. Unlike someone trial where 258 is there. And the framing of charge is based upon the charge sheet only. You don't even require anyone else. So I think I'm quite sure on police report we can't do anything but to proceed to write the judgment after available witnesses you have examined and you have tried your best to bring in those witnesses who were required. Is there anything else you all might also know? I've been out of touch with this CrPC for quite a lot of time since I went engaging. There were hardly any cases. 2019 was the last one. Yes, I'm about to say something. 249 is specific of complaint only. And dismissal is 204, right? We have Sar also, who has more experience on this.
No, in warrant trial,
Yes.
based on complaint, I have a bitter experience before the court of the knowledge judicial institution. I filed the complaint. The proceeding of that particular complaint was a warrant trial, and the parties already they compromised the matter. So I priced to the
Compound levels.
non-compoundable.
Okay, sir.
So what is the now this solution under the provision of CrPC? They kept on now postponing the date without appealing before the court. Also knows the ground level problem. So court is unable to dismiss. Then ultimately complainant he was bound to appear before the court and court delivered the judgment. So in non-compoundable warrant trial based on complaint,
You have to proceed.
yes, we have to
The
proceed.
only course may be caution at the record level.
Yes, under 482 only.
Ah,
482 on a high court can. It's like the moment we file the lost the FIR,
Can
there
be
is no
taken.
solution. Even if the police has no authority, court has no authority.
Ah.
Until and there is a specific provision in CrPC. So it has reached to the final end of the proceeding. So basically we have to see cognizable, compoundable and non-cognizable it's not a big issue. But it talks about, yes, the law legislation rightly pointed out, about complaint. What about the summon cases 258 is there?
And in police report, there is no course left.
Police report also, I think, court has to proceed
Ah.
till the,
I may not examine the complainant,
Yes.
but I'll have to do something and take the trial to the conclusion.
yes.
I think no judgments are there, no laws are there, but if some judgments would come, that if it's absolutely not possible, something should be done because it's taking the court's time also. When we are knowing, everyone is knowing That's going to result in nothing, and we'll be keeping that case only at those empty days where you are free. So it's harassment for everyone actually.
Ultimately, accused of that particular case was convicted. He filed appeal. During the pendency of the appeal, he also expired. So, I have bitter experience regarding this particular provision.
Yeah, if it's a some kind of small offense, it's still all right. But if it's a bigger offense, then the fellow compromise. They should have gone to high court, sir,
Yes.
to get it done. Because I think even after conviction, at the appellate stage also cases can be compounded.
Yes.
So this, I think we are done with it. So procedure to comply provisions of section 248(3) of CrPC while taking evidence of prosecution witnesses if convict does not admit that he has been previously convicted. CDE 248(3). Let's see what it is. Where in any case under this chapter, that is trial of warrant cases, otherwise than a police report, previous conviction is charged under the provisions of subsection 7 of section 211 and the accused does not admit that he has been previously convicted as alleged in the charge. The magistrate may, after he has convicted the said accused, take evidence in respect of the alleged previous conviction and shall record a finding therein. Subsection 7 of 211, that is pending of charge. Subsection 7. If the accused having been previously convicted of any offence is liable by reason of such previous okay, this one. I know the point. There in the IPC also there are certain sections which says if you are convicted of the same offence previously, you might be liable for a higher punishment. Right? So in that case, if that is the offence that has been attracted while framing of charge, then you have to ask him whether you have been convicted of this offence previously. The fellow might say yes or no. Now even if it was convicted by your predecessor which you know, right, then also you cannot say, oh, I know, I have this knowledge about it, evidence must come.
Usually in such cases, I always files a copy of the conviction judgment.
No, this is talking about complaint cases. Complaint cases. Yeah, even if previous judgment is there, I think, can you take judicial notice of it or it has to be proved? It has to be proved when it's an offence.
Conviction, previous conviction.
Yeah. How would you know that judgment that is filed by IO is a genuine one? Someone will have to say, I can write a judgment and bring. That's what we do. No? Even if we are knowing it's your own, could be your own judgment. Let's just think, you would not be trying your own judgment maybe. But it has to be proved. Or not. Or judicial notice of it can be taken.
A jailer can give a report in this regard. He can ask him to go to the jail, and also he can enter I cannot recall right now.
Yeah, but it has to be proved, no? In that case. Just can't file a judgment and just yes. So 248(3) is alleged in the charge, the magistrate may, after he has convicted the said accused, take evidence in respect of the alleged, take evidence, right? You have to take evidence. Previous and shall record a finding therein, provided that no charge shall be read out by the magistrate, nor shall the accused be asked to plead thereto, nor shall the previous conviction be referred to by the prosecution or in any evidence adduced unless and until the accused has been convicted under subsection 2. So I think the question that Sir raised in this point was, after passing the sentence also, which is unusual, because you have to comply with 248(2) also. Then you will be again telling him that taking the evidence of his previous conviction. What could be a difficult scenario in this? Is there any difficult scenario in this? Where in any case under this chapter the magistrate finds the accused guilty, that means conclusion of trial. You have found someone guilty, and there is one offence, which is alleged to be, which is previously convicted of also. So you will deal with the entire trial earlier, and then only proceed to deal with the maybe if there is a liability of enhanced punishment. That is very crux. So there is a liability of enhanced punishment for which he is charged. Otherwise, I think this section is not required. Charge is already there. There is an allegation that he was previously convicted of this, but you will not deal with this till the trial is completed for that particular facts of that case, or not the previous one. Once this is completed, then you move on to take evidence with respect to the charge for which he is liable. So only for the purpose of enhanced punishment, I guess. So that would ordinarily mean that you would not be punishing him for that particular section earlier also in the previous, because you will be passing the sentence itself. I think you will be leaving that section where there is liable of enhanced punishment and not sentencing at that very stage, but proceed to take on evidence and thereafter pass the sentence on that. Is that true? I think only respect to that, because it says evidence. Evidence has to come.
We have to put it to the accused in the charge.
No, you will be proving only the previous one. No, charge is already there, it says. Charge is already there for that.
But then if we pass a sentence, will it not be found as sufficient?
That's what Saul used to point out. No, that is on the ordinary circumstances. No, the section allows you to do that. How would you become founders of issue? It allows you, but it's quite extraordinary.
Yes.
That's the thing in this. So the even if the appeal, it would reach to the appellate court that what we have done is irregular, but the section saves us what we have done. No? We cannot see this with the same prism which we are seeing other trials. I do not know, like, if Sir is also, why this is so complicated, this warrant of trial cases. It could have been kept simple, no, like summons. I do not know the reason, the complication behind this procedure. I think in the old times, it was people coming to court as a complainant was not preferred. Maybe more than 2 years, you should go, it's cognizable and go to police station. You should have forced them to go. No? The 248.1 is also important. If in any case under this chapter in which a charge has been framed, the magistrate finds the accused not guilty, he said record an order of acquittal. It nowhere says right to judgment. Okay, order of acquittal it says. But as Sir was also telling me, Sir also discussed with the Honorable Justice Koskara, judgment we must write as per the section of that is there for the judgment. Right? So what our practice was, it was meaning order of acquittal only when you pronounce the acquittal. But writing a heading as an order of acquittal. In fact, in the order sheet itself also maybe suffice. I am not sure of this, but I think that is alright. That's what we have been doing. Order of acquittal, the accused is hereby acquitted under so and so section for offence under so and so section. And other courts in the other parts of the country specifically write section 240, order of acquittal bracket section 248(1) also. So that it's clear that under which section you are passing an order. In fact, most of the courts, I have seen them writing in the order sheet, your daily order sheet, the order of acquittal and under which section. And they even in fixing next date, they write, they might write for pronouncement of so and so. So,
let me, the reason for this, why we are required to be a little bit alert about this particular section of 248.1 is the ramification consequences is at the time of filing appeal. 386. 386 talks about order of acquittal. Until and only there is order of acquittal of the court, it's not talking about judgment. So that is the reason I think, filing appeal by the aggrieved party before the higher forum, definitely the appellate court will see what kind of judgment passed by the trial court. So they will go to the contents. The learned resource person also knows how the lawyer will argue before the court. So just to make alert our officers here, 386 A says in an appeal from order of acquittal. No one says judgment of acquittal. So just 353 says every criminal trial, there should be judgment.
No.
So just I think in a portion of judgment at the end, okay.
That can be. Even I started doing that later on, writing in bold caps out of the pocketer and the relevant person, which we ordinarily would write, okay?
Yes.
So that would at least save, even if it's argued heavily,
Yes.
so that no one can say that you never passed an order of pocketer. Okay, that practice you can start with. Nothing is wrong going to happen by writing just that much. So next is summons cases, which is very easy. Most of us have done summons cases. Now, few things in summons cases. Can we discharge the accused in summons cases? Okay, say. You said you nodded no. Reasons?
The chapter does not incorporate the provision for discharge.
What is the under which section we can discharge them? There is a section.
Under 250,
Shall be deemed to be under?
section 258, there is provision.
Yeah.
So
What certain conditions are there that needs to be fulfilled before you use that? Okay.
Yes, otherwise then on police report.
It is mandatory to hear both the sides in summons. Just saying, what's the difference between trial and summons cases? Both is of time. In summons cases, we very less time is required to finish the trial. The procedure is less cumbersome. But in trial of warrant, that's the very true. But our practice is that we are doing both the trials. We are devoting same time to both. We are not shortcutting the procedure. Actually, you can sort. There are judgments also. There are practices also. Do you need to hear a charge in trial of summons cases? Why? It's very important. Trial of the law is very beautiful, but we, the legal stakeholders, have made it so complicated that things have changed. 251, right? Do you need to hear the accused before framing something? I would still say framing word is wrong. But sometimes practice is so entrenched that it's difficult to come out of it. When in a summons case the accused appears or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make. But it shall not be necessary to frame a formal charge. So, yes, he was saying it's not necessary to hear the accused. What was the reason?
Because 251 says that only the substance of the accusation needs to be stated.
Well, but how that would still make you understand that the hearing is not required? Lawyers will insist on hearing. Actually, lawyers are not insisted on hearing, they are least bothered unless they are very serious about what they are getting good grade. The thing is, they are asking for time, next date. You get one next date for hearing on charge. And they will say hearing on charge also. Actually, when the charge sheet comes, whether it's a summons trial or warrant trial, a very good charge sheet does not come. The way the charge sheet ought to have been, police will file 99.9% cases with saying that offence has been committed, even if it is not there. This is not expected in summons trial cases where police are filing. It is expected that there are materials, otherwise we will close the case. Police will hardly close the case. Even if there is nothing there, they will somehow write their own story, which you will not find in 161. Right? From where they got that story, we do not know. And they put us in the middle. It's neither this way nor that way. You can't say there is no material at all, or you can't even say there is material. That's the kind of charge sheet that will come before you. Okay? So summons trial, law expected when framing this section that whatever comes from police comes a very good one. If there is offence, yes. Because law does not say to the police that you need to file charge sheet even if there is, no matter how heinous the offence may be. If there is no material, no material. Right? But usually you will find in summons cases, the police will file charge sheet. Okay, saying that this is what happened and you do not know, no one has told them how they go. Of course, those stories are correct, but the basis is not there in the charge sheet. Neither they have recorded in 161. They would hear it from the witnesses and write their charge sheet. Okay. So that is why actually the hearing before framing of accusation is not required under 251. because it is expected. Now when hearing is required, when there is a doubt or someone has to say something, no? Because if you contrast 251 with 239, it says you can even hear the accused. Okay, in sessions trial, sessions or next I got you can even examine the accused at the time of filing of charge, which is not there in 250. 251 straight away says, when in a summons case the accused appears or is brought before the magistrate, the particulars of the offence of which is shall be stated to him. You are bound to state what is the accusation against him. So there is no scope of discharging out here. What will you do after hearing also? Right? The only section is 258. Let's see what it says. In any summons case instituted otherwise than on complaint, a magistrate of the first class under the previous section of the chief judicial magistrate, any other judicial magistrate may, for reasons to be recorded, stop the proceedings at any stage without pronouncing any judgment. And where such stoppage of the proceeding is made after the evidence is there. So it can be done even before recording the evidence of principal witnesses. Okay, you can discharge, but do you really need a hearing to discharge in these summons cases? It was not an actual process of 251, but practice has come about that, but you can still insist the lawyers. I insisted the lawyers, forget about it, what hearing you want. There is the material, I am convinced there is material. If it's not there, I'll stop on 258. Otherwise, they would bring with all big fact arguments in summons case, converting it into a warrant case, the process, and we would be just looking at it. So try to mean some village, I need hearing. See, I'm not willing to give that whatever hearing. There's a way of dealing with these things, okay? Because they are accustomed to those things. They do not know. A lawyer may come. I'm not blaming any lawyer, but generally what is seen is they are hardly aware of what are these provisions. Only you are aware in the courtroom. Of course, there are good lawyers. So they will not understand what you are telling. They will go out and tell, this magistrate doesn't know anything. Obviously they will tell, okay, they will tell. He doesn't know anything. He said no hearing is required. Laugh at you. But as long as you are confident in your process, it's alright, okay. Initially I even wrote hearing is not required. When they would insist to me, no hearing, I would, okay, you can go to the appellate court, I will write my order. Hearing is not required in someone's trial. It says I shall state and I find sufficient materials to proceed against the accused. Finish. Even if they go, what they can do? They will go and argue that, I was not given hearing. What will the appellate court say? So what, whether he was given or not, unless so substantial they can show it, whether it was given or not, there are materials to frame the accusation. Your plea is, not required. You go back and face the trial. Appellate court will say that. But yes, if the matter, sometimes someone's cases are also complicated. So, the accused will say, not in a sense of hearing, tell the lawyer, you are finding it complicated, okay. Now you can tell the lawyer, okay, you can make your submissions. Or if you have read the charge sheet, you can always ask on that very day, what you have got to say, anything. Sometimes, knowledge comes from the bar also, not only this side. They might strike you with something. So in complicated matters, don't fix it as a hearing of charge in someone's cases. But if you get a substance of accusation, defer to so and so date. In that day you come prepared. Someone will insist you so much that you have to prepare. But don't try next that is fixed for hearing on charge. There is no process as hearing on charge of this. The law expects that what comes before you as a charge sheet is very good one with all those materials, and you will go and state offers. That is how one date is saved in someone's trial rather than warrant trial. If in warrant trial they ask you for date, you will have to give it. There's no, you will have to hear a charge. So someone's trial has this one step short. You need not hear it. You can get framed. If you are confident enough, there are sufficient materials, no matter what they say, you can frame. Don't I am framing that you will do whatever you do. As a propriety, you can hear it, but not as a mandate of law. Otherwise, what's the difference between the summons trial that you are doing and the warrant trial? Same thing. Right, you are devoting the same time to both the same, whereas summons trial is meant to concern the procedure, 258 is also meant to concern the procedure. Unlike which is not there in warrant trial, which we discussed just now, that what should we do if nothing is there? We have to go to the conclusion in warrant trial. Here you have sufficient grounds. 258 is such a powerful one that you can stop the procedure. It's a wastage of time for everyone. Another thing is, do you need to frame substance of accusation, not charge? Frame substance of accusation. We framed, even I framed, every one of us have framed it in detail, Because what we have learned is, for a charge, if you have not framed your charge well, that can vitiate the trial, right? That is always there in our backdrop. And we are so careful in framing substance of accusation. Not required. What it says, straight to the accused. Now, the problem is, we are not being able to differentiate between these two trials. What will the accused say at the most? The charge was not framed, or something was not framed properly. What can the appellate court say at the most? Either they will reach a conclusion not required, even if the appellate court will say that, okay, in framing it's much more better, it's much more clarity. Okay, but you need not be, you need not confine yourself to the section that is required for framing of charge. No appellate court will go to that section and say you have not framed the charge properly. Accusation is to be stated to it. These are simple offences, summons trial cases. Okay, up to 2 years punishment. So it's simple ones. At one point, I tried doing this, okay, but if no one is doing, in one training, one of the resource person for a long time back told us one very good thing, okay. If you do it as alone, if you try to bring changes alone, you will be at the receiving end. If we do it together, then no one can do us anything. Because if one magistrate is doing something else, other is doing something else, and only one trying to be smart, then obviously you are ousted. But if you can collectively, this is the process, this is our process. Then every court is doing that. Either they'll have to challenge in the appellate court or abide by what each of the magistrates is saying in their respective jurisdictions. But one of the magistrates only stating the accusation and saying, I have stated the accusation for offence under section 21. And it's sufficient actually in so much. It's saving time. The framing of charge requires time. You need at least 10 minutes out there in courtroom to frame it perfectly. So this is a shortcut procedure. Now if you are doing the same thing, there is no difference. I am of that view. None of our judgments, none of us have done this. It has never gone to appellate court. Now you are new magistrates. Just don't follow routinely. Try to study. Just don't use just your brain also. Try to study it. There are sufficient judgments which you will find of various cycles which says hearing is not required on this. Still we are not convinced because the judgments are not of our jurisdiction. Where we still fear someone telling you, no, it's required. Still it's up to you. Once or twice I just wrote in order sheet. Because I was convinced in one mind, but I was fearing also, okay? Sometimes when you don't have time, forget it here. Let it keep the fear aside. Just write it in the order sheet. Substance of accusation stated to the accused for offence on the swears. That is sufficient. Magistrate said to the accused, right? Signing is not required, but we are framing very formal charge. The section itself says not be necessary to frame a formal charge. You may frame it itself. It's not a necessity. It's not a mandate of law. But don't frame it as if it is in a charge. You can be very brief on that. On this day this happened, we are accused of this offence. Okay? And hearing is also really not required, but you have to handle this very carefully. Not that, don't be blunt and hearing is required. If something is there, keep it in your mind. You can say politely also. Okay? And then counsel, there is material, even if you take a date for hearing, I am going to frame the accusation. It's there. So it's up to you, you can say, it's okay, So I usually did not wait for giving substance of accusation in someone's trial case. That was the best I could do. Even if I was hearing them for that particular time in that very day, then to shortcut the procedure, I never gave date for hearing. Unless the case was complicated or the lawyer was complicated, something was complicated, then I gave a date the next week or so. That's all. That's the max I did. Otherwise, there would be no difference in someone's trial or trial. How to record evidence in someone's trial cases? Now, there is one section. Is there any difference in procedure? Of course, there is a difference, but we have not followed it. I have not found a single judgment till date. I have talked with many other magistrates also in the other parts of the country, and even the resource persons who came here, no one could say anything on this. I think there is one section, sir. I do not remember the number. It says, you can prepare a memorandum of evidence for someone's trial case. What is memorandum? To my mind, I tried to look for a lot how to make a memorandum of evidence. To my mind, it's not chief and cross. There will be chief, there will be cross. Now what the crux has come out, That's a memorandum which you put it there under your signature. Even the witness's signature is not required, I guess, when you are preparing a memorandum. Because we have prepared other kinds of memorandums. So it's a gist of what has occurred. Please Google one, because I don't remember this section. Memorandum of evidence, someone's trial. There is a section which says so, but none of us have done so far. Let's see who has that guts to implement that provision. 272. How fast you got it? In all summons cases, it says tried before a magistrate. Let's leave the other sections. And in all proceedings, let's leave that also. The magistrate shall, as the examination of each witness proceeds, make a memorandum of the substance of the evidence in the language of the court. Now see, it's so simple. Substance. Make a memorandum that to a substance of the evidence. I tried researching. You have been a researcher, but please find it out and it will be helpful to us. You can shortcut the procedure to other. Because now first हामीले पहिला भाइलेट गर्यो 251 मा हियर गर्यो डेट पनि दियो वारेन्ट ट्रायल ल्यायो देन फर्मल चार्ज फ्रेम गर्यो अर्को ह्याम्पर गर्यो अब एभिडेन्स पनि प्रोसेस छ यसमा पनि there's a detailed chief examination, detailed cross examination, which is not according to 274. So what to do? I tried to look for everywhere what is this memorandum of evidence. I didn't get it. I asked resource persons also who came here. I asked many, no one has answered this till then. How to go about this? If you can find about this somewhere, you can stand on. And forget those details there. You just ask the crux. Substance of both these. It's not required chief and substance of both and a memorandum signed by you. Finished. That's
In NIR cases where the complainant must find the evidence of affidavit. He cannot summon.
Is it a must?
I think now because the Supreme Court.
It's a certain judgment, right? So how would that make a
How are
difference?
you going to
Yeah, there will be only cross. We can still, compress that evidence and affidavit also.
compress the evidence of affidavit?
Because why that's the only course left. What to do? Compress what has come from the compress, actually the entire evidence. Because there will be cross examination, obviously. Okay. The law allows not to cross examine also, but
The longer the evidence is cheap, the longer the process.
that's why we don't have that practice. They are coming with that. Because they think that's the process. The court, the judge will understand only that. That's the view, So I do not know why this does not happen, or whether this section is outdated and doesn't work anymore. I don't know. Make such memorandum himself. He shall, after recording the reason of his that is not required, cause such memorandum to be made in writing or from his dictation in open. Such memorandum shall be signed by the magistrate and shall form part of the record. Finished. Occasionally, the witnesses did not even sign it. Such a short procedure. But I couldn't find a place where I could put my legs and say this is the correct procedure. The section says so. No one does it. Then what to do? So you can still find it out. Summary trial. This is a summary recording of evidence in summary. This is also no different than someone's trial. Okay, in fact, enact usually if you are not doing summary trial, we have to do reasons. But you can see all of us our files also we have done full. Forget about summary. It's a warrant trial.
Yes, sir. Like the law in 19.
Yeah. There are judgments to this effect, but that's what I said. It's difficult to come out of that practice which is there. You forget judgment, whether it be Supreme Court or unless it's directly of Honorable High Court in our state like this where the Honorable High Court is very nearby. In bigger states they might not remember that also. It's difficult to come out of that practice. Not only us, even the lawyers should change on this. They will come with detailed chief and all those things. Of course some cases are complicated when it involves companies, okay? Then you can go for someone's trial. But otherwise it should be summary trial. Brief judgment. What is the judgment to be in summary that reasons is required for reaching that conclusion. A brief reasons that will be changed. That is why I had 6 months or 4 months. The duration within which you should finish trial. 6 months. That is why it's 6 months actually. But with the process which we are following, 6 months is impossible. So, just to tell you, at present in our state, I do not know about others, we magistrates are conducting summons trial and warrant trial in the same manner without any difference. That needs to be looked into by you or another. I just try to consult well, just like I refused hearings. I refused, formal substance of accusation. And then those two I could consult. Then third I looked for this one, 274.1. I couldn't find anything on this to say that, otherwise it would be odd man out. In fact, if I had known what is the memorandum of recording of substance, I would have done. I couldn't find that one. Memorandum is possible. There's so many summons trial cases in our world. So if I start in one case, for my consistency as a judge, I'll have to continue in so many cases. And this opportunity I got at Eastern, where there are many summons cases. Now in a day, maybe I'll be finding these 3 substances. In a day, maybe I'm dealing with 8 summons trial cases. So by the time someone appeals against what I have done, I would be writing about 80, I would have conducted about 20 to 30 summons trial cases in the same manner. Suppose what I am doing is wrong, then again I have to deal with 20 to 30 judgments. That is a huge impact. And if that notice is brought to the High Court, about 30 cases he has dealt it this way. And the High Court finds something else, if they find the actual thing on this. So I was not sure. So be sure before doing this. I didn't get anything, anywhere, any place to be sure.
I have a question that is summons in service of summons in private complaint cases.
Yeah?
Service of summons in private complaint cases. In private complaint cases, especially where these persons are far away from places like Tamil Nadu or Andhra Pradesh, usually we are not able to secure their attendance because service of summons upon the accused through force is not recognized in this case. So that is why I think we have 2 matters in the case also. Because of that, the case is still pending at this stage.
It's a complaint, it is subject one, subject.
It's a complaint case. What I did was, I wrote letters to the jurisdictional magistrate and even to the commissioner of police several times. And then the summons was not executed.
Yeah, that reply will come to you after 3, 4, even after 6 months.
Yes, so
That they will get it. Or at least.
so much time.
Yeah, see, it's not recognized by post. Usually, postman gets delivered. The only thing you can hope is if the fellow is diligent enough, he may come. That's the only hope. But you are given one extra hope there, okay, instead of not posting at all. Especially in NIACT cases they are there, but now NIACT has that specific thing. Before issuing summons to someone outside jurisdiction, you must inquire. That's a different matter. Even if you inquire, you may reach that he is the accused and you will be sending summons in India. So usually we are relying in complaint. The process which you did through commissioner and concerned judicial magistrate is absolutely correct. But who bothers? They don't bother. There are so many cases. Go on magistrate from Sikkim. It's a police report or complaint case. What are these sections? Usually. What offences are these? That is cheating, etc.
So because of that, the case is pending for this long. I have written so many times to the jurisdictional magistrate.
You can issue a warrant then. But you see, the thing is,
Summons is not service.
that's what, that is the thing. But sometimes you can give you reasons what to do. Now your all processes has failed. That's of course correct procedure. Technical legal procedure, the fellow must have knowledge of what the court is asking. And he must deliberately not come to the court, only then you can issue a warrant. That's the law. But if you have exhausted all the procedures available to you, you can't go to accused. Okay? Then you can issue a warrant. But if the person is from far away place, the police will not go on their own.
Yes, that is the question, sir. Because the summon has not been received by the person. It has not been served.
Yeah, that's what I'm saying. Exhaust all the possible remedies. Don't be bluntly, issue warrant just on that. You try your everything. You can say that the warrant is a more coercible process which can be executed through police. But before doing that, if you have not followed the process of CrPC, then the High Court will say that you have not followed this process. You exhaust this process in letter and spirit. Then you devise your ways to do it. No one is going to say anything about that. Of course, the accused should come before you. He may not have got any notice, but something must come to you.
And sometimes the summons are written in other languages.
You can do one thing in that, engage the local police. You can write this in order also. I have asked the SHA to cooperate with the concerned police station and ensure that this summons get delivered. There is no way bar in this because they are at the field, no? You can't talk to someone, hey, I am sending someone standing, even to a magistrate. Of course, if you can sometimes, that's the last option, you can call the magistrate who is there. And the magistrate will obviously not know, there are so many cases. But you can call the SHA and say, I am having difficulty in this. Okay. Now, why don't you call the counterpart up? The complainant should give you which police station he resides, etc. That's his job also. Okay, he should find his proper address and put him under which PSC. Then he'll find some solution for you. Even if it doesn't come, something will come. That this fellow is here, it can be delivered this way. The person may not genuinely be aware of what you are saying. Local police would know where that person. It is very difficult. They would pay money and they would say no person is. These are all the things. But you can try this way outside the law also. Although sometimes, absolutely what you are saying is, I used to do, give me some money, I will go and deliver it. Because I know work is not being done there. No one is going. But we do get, summons from other magistrates and we attend to it very promptly so that it gets delivered. We ensure that it returns to the court also. But everywhere it's not like that, no? Naturally, they are dealing with 3,000, 4,000 cases at the minimum. Then they'll just mark it down to someone. There are piles of summons to be delivered somewhere. Yours will be the last priority. That's bound to happen. This is the process. There is no answer in law to this. And if everything was simple, why would it have been paid so high? It's a high-paid job, okay? At least we can say that much. So these things are the ones that actually puts us into worries than the law or the cases. This summons not getting delivered, accused not coming, all these things actually puts into worries. Otherwise, we can handle this law and judgment. What that? We can do it. If these things were efficient, we would have worked much more better. But these things, much of it is not in our hand. It's with the summons delivery officials, right? And once I was in Mangal, I had sent a warrant to SP Darjeeling, not to him, executed. I heard that he said it should come from High Court. That, but there is a CrPC provision. Initially through this local communication, through prosecution branch, I got it delivered. They said, not the High Court, they said something, some authority they said, hey, no, I sent it to SHO. The jurisdiction under which it is to be executed. He said it should come through his SP. So next I send it to SP, he endorsed it to SHO, and that's the process in West Bengal. So these are not much in our hands, okay? You can use the prosecution branch to do something, use your brain. I said these things are what gives you sleepless nights rather than the other things. Tomorrow, the case is pending for 4 months without appearance of accused. Now I go to last day. These are the worries, no? So you try your best and record it, whatever you are doing, what needs to be recorded, not all extraneous things out there, okay? But for exhaust the CrPC first. And post, you can do it. Sometimes they come by post. That they believe that more than anything. So if there is a WhatsApp number in an act, you send it to WhatsApp also, there is no problem.
That is what is the problem, sir. That is why they have it. I used to have to know this kind of thing.
What does the complainant say?
Complainant has been trying to help the court. He has been arranging for his court
only one accused. There are so many accused. So for them, everybody to come to the court, I don't know.
Usually they can come through BC, what's that?
No, so to serve them. The summon is not served to them yet. No, so even if it was one accused, we could think that X janala ka huncha. So there are so many of them. When will we find them? When will the summon?
Two will come, then the rest will not come.
Yes, that is.
And they will think that, I came, the judge is doing nothing, they will get vanished. That's what I said. These are the sleepless nights. There's no way out. You have to carry, you can't close these cases. Honorable High Court will be saying expedite, or your concerned district judge. You can try to explain, but that's the way our system works.
No, you can split also.
Speed person.
Split.
Yeah.
Just.
Yeah. If some of the accused had come, you can give reasons and split it at, But still, they should be declared absconding, sir. That's the problem. Sometimes the case against each other is so connected, it's difficult to split at, just two for two. Evidence against others also must come to find them guilty. So anything else we can discuss? We have 10 minutes left.
So just to clarify, because our judicial officer may, I think, come across this particular problem. I've been facing this problem and try to search for the solution. This 361, soon after conviction.
I know, sir, you will question this.
So, why to write this?
Professional.
Declining the application filed by the convict. Why to write? This says 361, the B plus, but has not done so. It shall record in his judgment. After conviction, 9362 says you cannot alter the judgment, except there is automatic error. So where court should write declining the application filed by the convict under section 360 or under Probation Offender Act?
What sir is asking is, when you pronounce a judgment, then you move on to hearing on sentence, right? And under CrPC, I think there's a High Court judgment which says, be careful on this, those cases which, what's the section which is there? 360. 360 you must mandatorily consider. Write something that you are refusing this. Petition is also not required for 360. Looking into the offences, you can release the person under 360 on probation of good conduct or after admonition for the things related here inside 360. And the Honorable High Court one case, which was my case only. The fellow appealed, he was appealing, on merits. But ultimately High Court found that I have not considered 360. I may have released a person. So deal first this person. So that will come back. So just, we all of are not doing this. Even if it's in your mind, we forget this in the courtroom. So 360 writes something on 360. There's directly 2 or 3 High Court judgment which says you are bound to consider this without there being any application or whatever it is. So if you are refusing 360, give reasons and refuse it in there. But what sir is telling is when to do this, Because the section says, it shall record in his judgment the special reasons for having not done so. So the question that do you need to really hear a sentence? In the law is we have to hear a sentence, no matter what. Even if there is no other option than passing one kind of punishment, you will have to hear it. There are judgment, in fact, there are a lot of judgments on this. So how will you write in judgment that you are not exercising this probation of offenders without hearing one sentence, right? That's the thing, sir, is saying. Because sentence comes after judgment.
Yes. While you incorporate this declining the application, 360 says write in your judgment, because we have already closed the judgment after signing it.
After
So it could be one thing, since on the 360, we are ourselves to apply our mind, which we can do. And you are, without hearing the person, you are of the firm view that you cannot, you will not apply this, but I'll hear a sentence. I'll pass sentence. But once you do that, your scope of releasing him under this probation is gone.
Yes.
So after writing a judgment and before order of sentence.
Yeah. Section says, you must write in the judgment, or declining 360.
But has not done so. It shall record in his judgment. And you have to read at the same time 362 also. You cannot tamper the judgment after signing it. until and until there is a review, there is a clerical error,
Our practice is we usually
automatical error.
do this during the stage of ordering sentence. Right, but sir is saying this section says you should record on the 360 in the judgment itself, we have not reached the stage of sentence also. So what is this? How to go about it? The only way I am finding out is if you are just writing the judgment on your own that you are not releasing the probation, later on you hear a sentence, but that by that time your one door is locked that you will not release a probation. But usually persons come with plea of probation only. Or should you give opportunity before writing judgment? That will also disclose your judgment, now you are convicting the person.
Yes.
Which is not possible.
So I have seen in Assam, district judiciary, they have written before closing the judgment only. They have already considered, but how, what way, what is the procedure is not clear. Because sometimes even the judgment of the learned judicial magistrate may go up to the ethics court. So challenging this and how to clarify, how to guide, how to give correct provision, it's not clear to me till now.
So can we, on the day of pronouncing a judgment, pronounce a judgment and give opportunity for...
On that day itself or
and
when?
then we can just write a paragraph then itself, just a paragraph, if we are considering or not.
But judgment must be signed in open court, no?
Yes.
You must
Before
sign it.
signing it, so we...
You cannot before signing it pronounce judgment. You have to sign it. The moment you pronounce, you have to sign it. That's the law says. You can sign it in a chamber also, that's a different thing. It says you must sign it in open court. And read out the operative portion of the judgment if you are not reading the whole.
That's what we read out and then it's here on 360 and then sign.
You mean to say you add below the judgment?
Just a
I
paragraph.
do not know. Some would try to say okay.
No.
She has given a solution, but whether legally it's tenable or not, it's difficult to say. You want to write a judgment that day, and that day itself consider and again write a small paragraph below it and sign it.
That can be also. Citing the problem of the CrPC.
Okay, judgment is over, no moment you cite it. It's over.
No, you are functions of
You
So
can't keep it.
I'll just pronounce my judgment, sir.
Hmm.
And then I haven't signed my judgment.
No. The pronouncement you are signing it, you have to sign it.
You have to immediately after
This
pronouncing, you have to
component-
sign. You have to sign and pronounce.
It's synonym. Pronouncing means signing. Finish. Pronouncing means signing.
So how is pronouncing signing?
How can you pronounce without signing it or something? The moment you pronounce it, let's read it. It says you must sign it.
353.
So pronouncing is
Sign
signing.
it, but
What do you mean to say? Okay, you want to pronounce
I
it?
just want to
Go back to the chamber. Oh God, I didn't consider this fact. What do you want to do? That gives scope for that. That's why pronouncing is signing. Or signing is pronouncing. Otherwise you can go back to the chamber. There are judgments which says, unless the judge has signed it, it's not a final judgment.
353, section 353, subsection 3.
It shall be dated and signed by the presiding officer in open court. So how can you pronounce? You cannot even go back to a chamber.
no, I don't want to go back to my chamber. I'll pronounce it and then I'll hear 360 sitting there itself. And then I'll decide and then I'll incorporate that paragraph in my judgment, print it out, sign it.
So this is-
But don't you need to give time for hearing of sentences?
because in warrant you have to give 1 day time.
Yeah, judgment. That comes in the way. I don't like what you thought. That
Not one
comes.
sentence, so it's a later if I'm conflicting.
Then what you are doing this one? Just hearing on whether to release him on probation or not.
360 or not, yes.
Then the accused will be giving all those pleas why he should not be sent to jail. No? Why will we? You will say,
But
just
that's
release
what
me.
360 is for, no sir.
No, that. But how will you deal? No, just can't deal with this one. You will be deciding at the same time that I will send you to jail, even if you don't write in so many words. Got my point? You may be writing on probation. Now you are of the mind you will not release it. Okay? That means you have considered that you will send the person to jail, which is a part of hearing on sentence. So why to keep another hearing on sentence? The problem is that even I don't agree with that, but a specific judgment which says you should give time for hearing on sentence. The more heinous the offence, the more. Let's take for example, suppose you have passed a life imprisonment. That's the only sentence that can be imposed, or even death. What will the person, how will he reduce the sentence? Can you come down below the minimum? You can't. But it says in the modern cases it's mandatory you give them time. When the ultimate punishment is only life in prison. No matter how much you hear, you will have to write sentence to imprisonment for life. So it really doesn't make it mitigating factors much. Only in those where you have discretion to come down. I think that should have, but the law has not distinguished on this. You must hear, you must give time. In fact, there was one case in our colony where it was sent back long judgment, saying that you give time to the accused to get a sentence. In fact, there are a few of the judgments of Honorable Justice Bhaskar Pradhan specific on this. You must give time.
No, the Salman Khan case also. AP was set aside on this particular ground only. No opportunity was given for hearing on sentence.
So far what we are doing is, sir pointed out that law is this, but we are doing something else. So far we are giving it right on. But I said there are High Court judgment which says you are bound to consider this while writing the judgment. In my case it came back, though I got transferred. It was remanded just for considering this. So there are a lot of things in law, that makes you think, okay, sometimes there are no answers, sometimes it's so difficult, and then what to do? We still have 5 minutes according to the exact schedule.
Yes. No, this my main intention of putting this particular topic in the session today is how to maintain the uniform in our state.
So we can put this question to all of you. You find a solution, you can call up sir and say, you can call any one of us. How can it be done best without violating the practice that exists and the law also, to find a middle path?
Yes.
What you suggested is, it's very difficult to think at the moment what you are saying is right or wrong, but I'll think about it.
No, how learned judicial magistrate keep in abeyance to exercise power under 353, then deal again at the same time in same breath 360 also. So first the learned magistrate has to comply 353 completely after that. Then only the question of dealing with 360 will arise. Convict.
Yeah, first you must convict. So, our idea is practical and seems to be, what to say?
So, but will it come under the judgment being altered or reviewed? That is the question. Because 362 says
Yes.
the judge will not alter or review. So whether me
good question.
considering, say she put that
It should not
question, but I
come.
don't want to ask.
Prima facie should not do. What she is doing, is proposing to do, should not be considered as being reviewed or whatever it is.
Altered.
Not altered. She has not signed the case. But that's a crude method, no? Let's find out something which looks judicially, good also.
No, there is
But it's a good one, okay, but
There is
is it
provide-
looking judicially good? Okay, now I'll wait for it.
There is a clause in 362 except to correct clerical and arithmetical error.
But that,
So which,
This is not clerical error.
or arithmetical error?
Not this. So to write the order a judgment on 361 is not a clerical error.
So my way is, there's no need of hearing on the 360. It's your one side, you can write it, I'm not releasing on probation. But that's whether I can block at that stage without hearing.
yes. And also, what if the accused then comes with an application?
And not under this, under section 4 of probation. But that's a different law. I think that can be still did. That's a different law. Though the wordings are almost the same, but 360 is different, it's a procedural, that is a different thing. So I think the scope of dealing under section 4 is still remains there. You can still deal with section 4 later on. But 360, I think in the judgment you should finish it. Either this or that. You can give a reason considering these things. But it will be very difficult, even if they come under section 4 of Provision of Offenders Act, to say something else. Because you already said something else. It's almost in a similar like section 4 in this. Little bit difference there.
So section 4 of Provision of Offenders Act again does not say that it has to be in your judgment.
Yeah, that doesn't say.
So,
It's different, no?
yeah. So that is easier. We can do that, deal with that. But 360.
That's right, we can deal that. 360 is my course is.
But what are the criteria or consideration to not proceed on the list?
Is there, I think, in 360? Not proceed.
Not to
Isn't there in 360? I have never released it, even in 360. Section 4 I have done it. I think it's there in section.
Any person under 21 years of age is convicted of an offence punishable with fine or imprisonment for a term of 7 years or less. Or any person under 21 or a woman is convicted of an
Expedient to do so, I think. That applies to no previous convictions of offender. If it applies to the court before which is convicted, regard being had to the age, character, or antecedents of the offender, and to the circumstances in which the offence was committed, that it is expedient that the offender should be released on probation of the court may. These are the grounds.
360.
Usually we can release persons on this. In fact, there are Supreme Court judgments saying why the courts are not releasing on the court. So usually 360 should be, should have been, I would not say being exercised liberally, it should have been come into use more than what we are doing at the moment.
There is one solution. I have come across the judgment of the Supreme Court which says if section 4 of Offender Act 1958 is applicable, then the provision of 360 is not applicable. So what court can do is I'll exercise the power under the Act, not under the provision of this procedure. So there is no legal impediment in the Offender Act. Even after writing the judgment also,
There is no.
yes, there is no.
If that judgment is there, then. But wouldn't that suppose someone would not come with an application under section 4? Then what would happen is I am not considered there also, here also I cannot say on my own.
No, somewhere the Supreme Court says the moment provision of Offender Act is applicable, the question of now invoking 360 does not lie.
So what if somebody comes with the application of 360? Can we return back saying that no?
Yeah, you
come under
have to
section
rely the
4?
Supreme Court saying that yes, Supreme Court says that this particular act is already extended in force. You submit an application under that particular provision. Supreme Court somewhere says, I can recall.
So I think 360 is for the court to exercise, and Provision of Offenders Act which gives right to the accused that.
That's why I am saying I would not hear them while writing judgment and pass out on the 360.
And if he comes
4 is still open to me.
But the moment you proceed ahead, the problem now is there is a hurdle. How you justify the order passed by the concerned court on 361, not entertaining the application? That is the order. How you justify your order to be applied, so that the every person may not challenge before the higher court.
And the courts before me is I will not wait for them to come. Because every time they will be saying, judge will tell and then. And some, even if we are not dead on the 364, hoping that 4 will rescue us, some lawyers would say, minimum punishment. I want to go to jail but give minimum. So in that case now, I'll have to forcefully say, no, please give me section 4 application. So that will lead to, this judge will definitely ask for section 4. This is his problem out there. Let's beat him somewhere. Let's give him some pain at this juncture. They may do that also. But these are all the things of our judicial system. They will be giving us pain somewhere deliberately. It's not that they are being bad, okay? Of course, just imagine yourself at the lawyer's shoes also. Every day you are dealing something, you have told your client if it's good one, don't worry, I'm going to do it. If they are finding difficult before the judge, they struggle on the bar side also, okay? Inside the courtroom. You see from this side only. But it's difficult for them to get through us also. And moment they don't get it, of course, that's their livelihood there. Our salary is coming on first, we know that. But theirs, if someone has promised 5 lakh, I'll give you if you just do this, and you have fallen in that, imagine 5 lakhs lost. Gosh, we are not their relatives. So just, they will do what advocate proficiency will demand. They will do, that's their professional job. They may look you bad also, that's their job. Unless someone is so personal against you, that every time he is finding holes in you, then we'll have to tolerate lawyers. Just like Devika's stories, there's just judicial officers are there, so everything. What was one of the lawyers who, this man would not sit in the courtroom till he goes out. What's his name? Something. He comes to West also, something, that domestic violence lawyer.